ಏನು ಸರ್ ಸಿಟ್ಟಿಂಗ್ ಲೇಟ್ ಇದೆಯಾ? ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್? ಸಿಟ್ಟಿಂಗ್ ಲೇಟಾ? ಏನು ಸಿಟ್ಟಿಂಗ್ 11 o'clock?
Permission, my lord. One
matter for 230, your lordship. This honorable court in earlier PIL, your lordship, has directed respondent authorities not to allot open spaces, public spaces and fire exit places for construction of shops, your lord. Instead of complying that order, there is illegal construction of shops going on, your lordship, in the KR market premises. There is no space in case of fire accidents to escape from the premises, your lord. Your lordship may kindly have it at 2:30. Tomorrow, your lordship.
Second December.
Your lordship,
Second
tomorrow.
December.
No, 14 contempt matter, my lord.
What's up?
That single judge has set aside my order directing the respondent number 4 to respondent number 3 to consider my request. After 3 months, respondent has not considered my request, my lord. And
January.
fresh matter, my lord.
What is the urgency?
They have not released my 30% of sites, your lordship. I'm a developer.
Not raised?
They have not, respondent number 3 has not released my 30% of the sites. Respondent 3 has got direction from the learner single judge to release 30% of sites, my lord.
December.
Actually, stop. Serial number 42 and 77, my lord.
42 and 7.
42 and 77. I seek one adjournment because my father-in-law was expired.
When do you want? January?
Any January.
18 January. 7th January.
42 and 77. Much of us.
Matter is filed 15/7/2024. Matter is not yet listed for admission.
What is the urgency?
Urgency is this, my lord, there is a direction by the Learned district, Learned judge to observe the civil court.
We'll say 8 January.
That is a case of human rights.
8 January.
8 January.
8 January.
Day after tomorrow.
No, day after.
Any date maybe.
Given.
My senior is not well. He's going surgery, undergoing surgery. I need 3 weeks of time.
52. Ninth February. 9th January.
My lord, serial number.
82. Last occasion, Your Lordship had very kindly granted me that liberty to mention it in the morning for hearing, you know. So if Your Lordship would have it at any time convenient.
What is the urgency?
My Lord, the stay which has been granted of inquiry proceedings, the other side has been served, Your Lordship had been pleased to grant the custody by hand service. The reply is on record now, my Lord. It's a very short point.
Can I take up tomorrow?
Tomorrow.
You are coming from Delhi. All right. We'll take up in course of the day.
One submission, my lord, it's serial number 82.
Unless doesn't read, we'll take up in the second half.
Second half.
My lord, serial number
One
42.
submission at serial number 82, my lord.
Serial number 38.
Yes.
The content matter,
Which one?
but I'm moving in. Compliance affidavit has been filed. My lord, subject to your lordship's convenience, my lord, your lordship may have it any date this week.
Why?
My lord, compliance affidavit has been filed, my lord.
So it is over.
Please, my lord.
It is contempt doesn't survive.
My lord,
compliance.
my lord, that needs to be considered, my lord. The other side has filed a compliance affidavit. My lord,
So what is the urgency? It will come. Why we are filing memo? Yes,
My lord, serial number 38, my lord. I
38.
request 10 days time.
Pardon? (22) petition. Why you are seeking? No,
My lord.
let it be called.
So
My serial number.
commercial appeal, my lord, so matter
Pardon
has been,
again. Little loudly.
commercial appeal, my lord, the matter has been settled between the parties. We need to file and compromise petition. So may kindly have it this matter on 27th to file and compromise petition.
27.
Yes, ma'am.
27.
serial number 19. I forgot complainant, my lord.
Yes,
Serial number 49, my lord. 2 weeks time may be granted.
49.
My lords, in serial
2 weeks
number
will- 2
My
weeks
lord,
will go to
number-
10th February,
My lord, serial number 64, my lords.
60,
My lord,
64, my lords.
64.
my lords, in serial number 49,
Council on record has some personal
Pardon?
inconvenience today, my lords.
64 will go to whatever date you want,
64,
Eighth of-
my lord, is a
8 January.
published, my lords.
my lords, in serial number 49, my lord, date may be fixed, my lord.
In light of the liberty granted by the Honorable Supreme Court, we are moving this matter to seek clarification of my lordship's order.
That
We have annexed the Supreme Court.
transmission of the,
Very much. There was ambiguity created with regard to my lordship's order, so we made a mention.
no,
to the
this is,
court. We'll be moving my lordship's court to seek clarification. The first order, second page, my lord.
we have seen.
But with regard to the history of the case, I have annexed all the orders of the Supreme Court. Any date convenient to this honorable.
4th,
My lord,
4th,
January, my lord.
no, December.
December 4th, not an issue.
My lords, serial number 19, I'm for the complainant in this matter, my lords. I have my learned senior counsel has some difficulty, may be taken up next week if possible, my lords.
Which one?
19, my lords. I'm for the complainant in the matter, my lords.
19.
Please. Learned senior counsel has some difficulty. There's some submissions we have to make, may be taken up next week if possible, my lords. Or any other date convenient to this honorable court, my lords.
19 is what? Whichever date you want. It is complied with, Mr.
My lords, we have some submissions. Our submission is not complied. That's why we want.
That will call out at 2:30.
My lords, my learned senior counsel not available. That's why I'm asking for a short date to any time next week if possible. That's why I'm seeking for it. my
It is complied with, completely
lords.
complied.
No, my lords. If we be taken up next week, my
You
lords,
can make submission when it is called out.
my lords, I'm led by a learned senior, my lords. That maybe please take it up
Also
anytime
there-
next week. I'm sorry, my
Contempt
lords.
petition, nothing more to be.
No, my lords, there is some submissions we'd like to make. Any time next week if possible, my lords.
No, it will be called out at 2:30 and we'll deal with in accordance with merits, subject to what you are submitting.
Please, my lords.
You can't dictate on the court.
Please, my lords, 2:30 it is, my lords, please.
This is just contempt matter.
Please, my lords.
It's entirely complied with.
Please.
If you are able to convince the court not comply, we grant time.
Please, my lords.
Yes, yes, Mr.
Serial number 49, a date may be fixed, my lord.
49.
I appear for appellant.
49 is already adjourned. Somebody mentioned. Somebody mentioned. Yes,
My lord's date may be fixed in that matter, my lord, serial number 49.
yes, Mr.
Number 46.
46. Yes, what do you want?
And it's on 2 weeks accommodation.
It will go to February 11.
With my
Yes,
lord's
madam.
kindly, my lord.
Who is on video conferencing? Yes,
Serial number 82, my lords.
serial number
82, my lords.
82.
Yes, my lords. I have filed cross objection. In addition to that, appeal same may be put up, my lord. Today itself, matter may be heard, my lord. I am ready, my lord.
It is already granted, your matter. Yes, yes, next.
With my lord's kindly, my lord, serial number 48, my lord. I appear for the appellant. My lord,
48.
I request for a short date, my lord, in this matter.
Court
Some-
will not be there. It will be then 14th of January.
Please, my lord.
16th of January.
Please, my lords.
My
Okay.
lord, serial number 49, my lord, I have
48.
correspondent.
16th of January as requested by Learned Review. Yes, madam.
Serial
Obliged.
number 49, my lord, I appear for respondent. My lord, date may be fixed, my lord.
It
for
must
this
have been
matter.
given date.
10th
All
February.
matters are
No.
given date. Yes.
In serial number 46, interim order.
Serial number?
Serial number 46,
46.
interim order.
Interim order will be extended.
Serial number 100 and 102, my lords. 2 weeks time may be granted to comply the office.
100 and
100 and 102, my lords.
100 and 102. All right. It will go to 21st January. Both 100 and 102. 100 of 21st January, 102. If not connected, it will go to 4th February.
Serial number 100 and 102, my lords, not 10.
That is what we have adjourned.
My lord, serial number 104, my lords. My lords could take up the matter
No,
at
104.
104. My lords could take up the matter at 2:30, my lords. The urgency is that, my lords, is the BBMP along with the other officials. The learned single judge has passed an order to pay compensation for a person's building getting demolished. That person is not even the owner of the property, my lords. The case is pending.
No urgency.
My lords, learned single,
Serial number,
No urgency. We'll take up.
please, my lords.
serial number 60, a contempt petition.
60.
We were supposed to
Serial,
have
serial number
Number 60, contempt.
60.
62.
62. So what is the request?
The matter has been appealing for the past 4 days. They are not compliant with the complaint report has not been filed before this arbitration. In the meanwhile, he has filed a writ petition and obtained an order.
Very good. It will not survive. Contempt will not survive.
62.
The directions.
Order under contempt is stayed. Order brought under contempt is stayed.
Not got of the.
Then you come when it is called out. No mention. When it is called out, you make submission. No wasting of time in mention. Yes, madam. I will hear that.
No, which number it is.
Yes, start.
So list number 1, so contempt matter, still number 1. Let's appear for the petitioner. Issue the
Order my lords to issue, permitting me to participate my lords in a tender process. Lords, I wrote a representation seeking permission my lords by a specific order. Lords, thereafter an application for modification comes to be filed my lords by the responding. That comes to be withdrawn my lords, and the order passed my lords, single my lords is not complied with. I was given a specific permission to participate in the tender because my lords, my tender my lords, which I was given the work order was terminated. The termination was initially stayed my lords. Thereafter,
This tender process is going on.
my lords, that tender has been stayed. My lords. The tender has been stayed. The
Tender has been changed.
My lords, the subsequent tender where my lords, the interim order was granted. Now my lords, they have withdrawn the tender. After my lords, the non-compliance of the order, they filed an application for.
Direction is given in your favor to permit you to submit the bid.
Yes.
Now that tender process is going on.
But that tender has been withdrawn, my lords, by the respondent.
Then what?
My lords, but the direction, my lords, was to give me, my lords, permission to participate in the bid. My lords, then they file an application for modification. My lords,
one
kindly
or-
hear me out for a
For
minute.
good or bad reason, if that tender process is not surviving,
My lords, the tender process may not have survived, my lords, but they've called for one more tender, my lords,
file
thereafter for
again.
the same amount of bid.
approach again, we will on a single judge
My lords,
to seek press order about the
my
next.
lords, may kindly see, my lords, the sequence. My lords, initially, my lords, an order was granted in my favor. They, my lords, asked for modification of that
Matter
order.
tender in respect to which you are given right to submit bid is
Yes.
withdrawn.
My lords, that, yes, the bid is, yes, the tender is withdrawn. My
No
lords,
There is no contempt.
my lords, the contempt is, my lords, may I show this, my lords?
There might be an illegality.
My lords, there is,
Action not permissible in law, but not contempt.
my lords, contempt, my lords, may I persuade my lords to look at the only one order, my lords. Initially, my lords, an order was passed in my favor. My lords, may come to page number 17 for a moment. I'll just take, my lords, only for 1 minute. Let's page number 17. I'm so sorry, my lords. Page number 17, my lords. Annexure A17. My lords, at the bottom of the page, my lords, paragraph number 6. I may read minutes. I deem it just and appropriate to dispose IN number 3 by modifying the interim order dated so and so and by permitting the respondent number 2 to proceed further pursuant to annexure A, subject to the condition that the same would also be subject to the final outcome of the petition. The petitioner would be entitled to participate in the proceedings pursuant to the impugned tender, which would also be subject to the final outcome of this petition.
So that impugned tender is withdrawn.
Now, my lords, the impugned tender is withdrawn. However, my lords, kindly see, my lords, an application they filed for modification. My lords, my lords, there was an order which was passed with consent when both the parties were heard. Thereafter, my lords, they try to modify the order. My lords, may kindly see the prayer for a moment in that IA for modification. Page number 232, my lords.
232.
232, my lords, please. (234), my lords, is the operative portion where the prayer is there in the IA. My lords, what they do is when the order is passed in their presence, they don't comply with the order. Then, my lords, they seek to modify the order, which comes to be withdrawn by them. My lords, because permission was not granted to me, my lords, I was not permitted, they withdraw the tender. My lords, the order in my humble submission, my lords, sees the contempt of the court passed by the learned single judge, my lords. Even though as on today, my lords, the tender may have been withdrawn. My lords, what has been done, my lords, they have circumvented the order of the learned single
The
judge.
order was passed,
My lords, order was passed, my lords, on 24th of July, 2024.
permitting you to submit the.
Please, 25th, my lords, I write a representation.
22,
24/7/2024, my lords.
24/7/24 order was passed.
Yes.
And the tender was withdrawn on.
My lords, that was withdrawn in the month of October, my lords. Subsequently, after, my lords, in August, they request for modification of the order. I was not permitted. Then, my lords, they withdraw the tender because my permission was not granted. My representation is in the very next day, my lords. On 25th of July, I write a letter saying this is the order passed by the learned single judge. Kindly permit me to participate in the tender. That, my lords, is not granted. Then they seek for modification. They withdraw the application because the learned single judge was not inclined to interfere.
Stated that the impugned tender is withdrawn.
Minutes in the petition, I have minutes. I'll just confirm minutes. Minutes, when I filed the contempt minutes, it was not yet bid on minutes. In the month of October, it is bid on. 25th of September is where I filed the contempt. I'm so sorry. Minutes. That's why submission is this minutes. Not only do they not permit minutes, I understand. My grievance is before the learned single judge with respect to the first tender. Minutes, they don't permit me in the first instance. Then minutes, they try to modify the order, which also they don't succeed. Then minutes, they withdraw the tender.
Contempt jurisdiction, technical jurisdiction.
I understand. Minutes,
Within the four corners of direction, we can't go beyond.
Minutes, I board on minutes. As on today, minutes, the order is still minutes. It was contempt because minutes when they withdrew without giving me the power, without giving me the permission. I'm sorry, minutes. They have committed contempt of the court. As on today, minutes, my grievance as against a fresh tender minutes. I understand. Minutes, but kindly look at the conduct minutes of the respondent. I'm only on this minutes. Permission is granted in their presence. They were heard. Interim order was modified. I was given the permission. Then minutes, they try to obtain a modification of the order which they are unsuccessful in. Minutes, in order to circumvent the order which is given in my favor, minutes, they withdraw the tender. Minutes, if the order is granted in my favor, minutes, I'm not here asking for the relief at all.
Come with a better contempt. He has heard learned advocate Mr. So-and-so for the petition. By filing this petition, the jurisdiction of the court under the Contempt of Courts Act 1971 is invoked in respect of order dated 24/7/24. The said order is passed during the pendency of the writ petition, whereby inter-alia, the petitioner whereby inter-alia it was provided that the petitioner would be entitled to participate proceedings pursuant to the impugned tender, which would be subject to the final outcome of the petition. The impugned tender was after the order was passed on 24/7/24, it is the case of the petitioner that he was entitled to submit the bid and participate in the tender process as directed by the learned single judge. However, it was submitted that in the month of October, the tender was withdrawn and the petitioner had no opportunity to participate and submit bid. Paragraph. When the tender is withdrawn, it cannot be said that any contempt is committed by the respondents. Also, the court cannot compel the respondent to continue with the tender and hold thereby that they have committed contempt by not accepting the bid of the petitioner. Even if the action in withdrawing the tender or withdrawing or cancelling the tender is taken and it does not and the same is not strictly legal in the submission of the petitioner. Even then, the contempt jurisdiction cannot be invoked. Full stop. The remedy for the petitioner would lie elsewhere. Full stop. There is no willful contempt in the facts and circumstances case. Therefore, the present contempt petition not entertained and disposed of the court.
Yes. Seal number 2.
Notice returnable on 8 January.
Seal number 3. Ashok, Vanidini.
Yes, this is interim order, will not entertain. The order brought under the contempt is admittedly an interim order. Main proceedings of the writ petition is pending at large. Where is the order?
Order is dated 1st of October, Mirror. Page number 15.
Pending at large. Full stop. What is directed in the interim order is that the order of conducting survey and submitting report to the court will not come in way of authorities to remove the encroachments. Full stop. Whatever directions paragraph are given in the order, said order dated 1st October 24 are interim in nature. Rights of any of the parties are not finally crystallized. There is no trapping of finality in the order. In the aforesaid view, the court is not inclined to exercise the contempt jurisdiction. The contempt petition is accordingly not entered without going into the merits of the case. Yes, next.
Number 4, Mr. TP Vivekananda.
They're not.
Notice returnable on 8th of February. Yes. We are not entertaining. It is interim order. You can submit, you want to submit.
My lord, that interim order was given not to disturb that, my lord. There is a
You
clear.
go before. Interim order, we are not invoking the contempt jurisdiction. Yes, consistently.
They demolished the compound wall.
Pardon?
They demolished the compound wall, my lords, which is.
Go before, learn a single judge. Work out the right and remedies.
My lords, it's a clear-cut violation of your lordship's order.
There is no finality of rights of any of the parties at this stage.
Number 5, Stage Maltesh.
Hello.
You add the petitioner is at liberty to approach the court with which the order is passed and work out his rights and remedies. Also, this court has not expressed any opinion on the merits of the case of the petition. Yes, next.
Number 5, Mr. H. Maltesh.
Notice written on 9th of January.
Please.
Number 6. The response.
For the complaint.
It is for orders.
We have issued interim directions. The complainant and the court commissioner shall provide the details as required by the respondents to activate the website as directed by the trial court. The respondents on furnishing the details shall give effect to the directions of the trial court and this court in writ petition. As a first preference, both the parties are at liberty to exchange the details and ensure compliance with the directions. However, if any difficulty arises, the court commissioner as appointed shall facilitate compliance of the directions. Needless to observe, the court commissioner shall require the details from the respondents that are relevant only to the extent of implementing the directions. As can be seen, the dispute is regarding sharing of the credentials, passwords of the website server. The court is also of the opinion that the respondent's concern is on the security of the data of the third parties also cannot be ignored. If the court commissioner requires access to the database of the respondents, upon such a request by the court commissioner, the respondent shall provide such access for which the complainant, court commissioner, and respondents will meet at place of their convenience. 4 weeks is granted for compliance of the directions of the court and in the light of the observation made in this order.
Not one submission. In I number 3, the learned trial court had imposed a condition that money has to be transferred. That is still pending. We have sought for a clarification before the trial court. That is pending on 5th of December. That is also important for the compliance of this order.
In the course of hearing, complainant has made a submission that they are prepared to deposit that amount. Their submission is placed on record.
My lord, under protest, that amount obliged.
You submitted in course of the hearing.
Much
You recorded. We are not directed, but we recorded.
Obliged me.
Seal number 7. Mr. Sanjeev BL.
So both the writ
Okay,
appeals are disposed of by common order.
Yes, sir. No.
In view of the above reasons and discussion, following orders and directions are issued. The Regional Provident Fund Commissioner shall proceed to re-examine the determination of the liability amount, which is presently fixed by him as per his order dated 26th October 2017. In the above process, respondent 2 shall give opportunity of hearing to appellant BBMP as also to the other necessary parties. The BBMP shall be permitted to produce the additional and all other documents which may it seek to produce and rely on in support of his case that the payments are already made by the contractors. Respondent 2 shall accordingly decide as to whether the payment or contribution to the Provident Fund has already been made by the contractors for the power karmis who worked for the period concerned under the contractors. The exercise shall be completed within a period of 10 weeks from the date of receipt of the order. It is provided that in order to enable the respondent number 2 Provident Fund Commissioner to undertake the aforesaid exercise, order dated 26th October 27 passed by it shall not come in way, and that exercise shall be undertaken notwithstanding the said order.
Please. Please.
Both the appeals
Grateful.
disposed of in terms of.
Please. Not only one submission, Lord, is they have now in the pendency recovered this money. The Provident Fund Authority, Lord, it should originally go to the credit of those persons. That should not be done. This money can be kept in deposit to await the outcome of their order. Because after he made the order, my Lord, he attached the bank account. Then they recovered this money from us.
Who?
The money is with them now. They should not in turn part to some so-called employees. Let this.
They have recovered the money.
Yes, they have recovered, my Lord.
Entire amount.
Yes. Entire amount. In fact, I made an application to say direct them to redeposit. That your lordships are not inclined to consider. But I'm only now saying, my Lord, that money which they have recovered may be kept in deposit in some bank, ultimately to.
Add paragraph 6.2. It was undisputedly stated that the Provident Fund Commissioner Office has already recovered from the appellant BBMP the amount of rupees 90,18,89 719, which is determined under order dated 26th October 27, which order is now under re-examination as per the above direction. It is stated that the amount is lying with the
respondent,
lying deposited
BF
with the
authority.
respondent, full stop. Since the press exercise of determination is directed as above, the Office of Respondent to Provident Fund shall not deal with in any manner.
And keep it in a deposit to outcome.
It has been already deposited.
Shall not part with the amount in favor of any party, and the amount shall be kept in a fixed deposit with a nationalized bank initially for a period of 1 year.
My lord, it has been already deposited in the account of the. My lord, it has been already deposited in the account of the PF. So let it be lying there, and it will earn interest more than what the banks gives.
If not already invested.
Please.
The PL matter, seal number 8. Mr. Gurudev, I get in mark.
Yes, in this matter, I pray for short accommodation, my lord. Senior used to appear, my lords. He has got some inconvenience. He is not keeping well, my lords. Short accommodation, my lords. Any day, 2 weeks, my lords.
When do you want?
Any day, my lord. 2 weeks after 2 weeks.
2 weeks.
Next week, my lords, any day, at least.
3rd of December at 2:30. On that day, if your senior is not there, you can.
Oblige me.
Seal number 9.
Lord's permission.
Sankit.
My Lord, this is the matter to do with the data protection laws. My Lord's order of 25th October, my Lords had directed that let there be compliance with the IT Act.
It is now their contract.
Yes.
Additional contract is.
Yes,
entered.
my Lord, they had submitted a draft contract in which there was a reference to an addendum, an annexure, which also has now been provided. There is a dichotomy that the agreement creates as to what is data protection and data processing. The agreement is largely in line with what the petition has sought. The only request I would make is that the data processing agreement should also make reference to the Information Technology Act, because today it only makes reference to the EU legislations. And the whole question is whether they're following the IT Act or not. And if that is included in the definition of the data protection legislation, which is defined in the agreement itself, that would meet the purpose, my lord, and that is the intention.
Now it is time for you to approach your learned friend.
Yes, but I've
Our role is beyond this, we will not travel.
I've quite candidly made this.
Actually, this is
made
taken
this
care,
request.
my lord. I don't know, maybe they have not noticed it. It's taken
See
care.
the last affidavit filed by the party.
Please, my lord, I bow down. I am for a moment not suggesting that it does not attempt to comply. All I'm suggesting, my lords will see the agreement that has been filed. It defines data protection laws as the laws applicable in the EU.
They have committed in their affidavit and
Please.
before the court. That not only that they have entered into the supplementary agreement,
Yes.
but they are going to abide by this, which act?
The Information Technology Act.
Information, IT Act, my lord, was not referred. That is now referred in the agreement.
So it will cover, yes, it will cover everything.
I am only making this suggestion that the agreement that has been filed today, in that the definition of Data Protection Act laws does not cover the Information Technology Act, and that ought to be included. That's about it. And even if a statement is made, that would solve the issue. That will take care of the problem.
But it is mentioned in information.
Please, my lords, I have the agreement that has been
In the agreement which we have filed, kindly see, my lord, page 19, along with my application for permission. There are 3 changes that we have made, my lord. Kindly take my application dated 13/11/24, which is an application filed by me for permission.
Yes.
In that, my lord, kindly go to page number 18. Their main grievance was IT Act is not referred. Page 18, para 23.4. Vendor service provider shall ensure compliance with all applicable law relating to services under this agreement, including but not limited to Information Technology Act 2000 and the rules thereunder concerning or in relation to rendering of services by vendor, service provider, or any other modification changes in the applicable law by the legislators or by regulators during the currency of the agreement. The vendor shall comply with all data protection laws applicable in relation to services under this agreement and shall ensure that any data provided by the party under this agreement is treated as confidential. For the purpose of this clause, data protection law means all directives, statutes, regulations, orders, decrees, decision, or any other like instrument, whether enacted in India or any other relevant jurisdiction, which pertain to the protection of privacy and confidentiality of personal data, including digital data protection under 2023, upon its provisions being notified, along with the rules framed thereunder, as well as the Information Technology Act of 2000, along with the rules framed thereunder, specifically information technology, reasonable security practice and procedures, and sensitive personal data or information rules of 2011 as amended. So this covers everything.
Yes.
Next para is what last time, my lord, they said you want to see that addendum. Lord, what has happened is for EU countries, they have little more stringent regulations. So some of our clients, my lord, are overseas citizens. Maybe they are residents of EU. So we needed a blanket thing. So we put the next clause, which is covering relating to EU only, my lord. Kindly permit me to read that, clause 24. The vendor service provider shall be required to execute data processing agreement as per the format furnished in annexure that complies with the requirement of the current legal framework in relation to data processing with the regulation, that is EU, European Union, of the European Parliament and Council of 27th April 16 on the protection of natural persons with regard to processing of personal data and on free movement of such data, and repealing directive number so and so, any other data protection privacy laws applicable to the services. Once the provisions of the Data Protection Act are notified, the vendor service provider shall be required to execute an addendum to the data processing agreement that complies with the legal provisions.
Now this versatile card technology is the highest bidder. There are 3
Yes,
bidders.
there are 3 bidders, my lord. We have now, my lord, according to our procedure itself, we don't give to one person. All of them, my lord, L1 will get the highest, L2 and L3 has to agree to match.
But
Then all 3 are given order.
Other bidders are not filed such.
All 3 have filed affidavits.
All 3 of
Yes, yes, my lord. Your lordships will get those affidavits in the same compilation. Begins, my lord, at page number 23.
Only one is filed.
23 is one, my lord, page 23, one Hemanathan.
Yes.
Then 25
It is there.
is one Prasad.
It is.
And third one is one,
I did not see. It is there.
all 3 are them.
So your senior has given you a very onerous task.
No, my lord, in fact, because quite candidly, because that most of the concerns have been taken care of. The only issue is what clause 23 deals with is data protection. What clause 24 deals with is data
Petition was
processing.
filed in the nature of public interest petition, praying to set aside the request for proposal dated 19/7/24, which was for into inward comma selection, which was for into inward comma selection for vendor for procurement, personalization, dispatch, tracking, and management services of EMV cards, into bracket contact cards and dual interface cards, including NCMC, bracket over, and variables, WEARABLES for Canara Bank. Full stop. The main plank of grievance raised by the public interest petitioner that the tender contract, which is going to be executed by the respondent Canara Bank, would be non-compliant of the provisions of the Information Technology Act 2000 and Information Technology integrated reasonable security practices and procedures and sensitive personal data information. Bracket over. Rules 2011. To further submit that, it would lead to breach of privacy of data, of banking data of the customers who deal with the bank, and therefore against public interest. Paragraph. At the time of initial hearing, after hearing all the sides, the court had an occasion to pass order on 25/10/24. Full stop. The relevant part thereof is extracted herein. Then paragraph 2 to end, 2 to 7, quote the entire paragraph. Full stop. After the aforesaid order, the petition was adjourned from time to time. It comes up for consideration today. Paragraph. The record of the petition accompanies the application filed by the respondent Canara Bank, whereby the respondent bank has produced on record a draft supplementary agreement, which would be executed with the successful bidders. It is stated, paragraph, in the interim application. It is interim application.
Yes, IA number 1 of
IA
20.
number 2 of. It is stated in the interim application that the draft contract agreement clearly provides that the vendor / service provider shall ensure the compliance with any modifications, changes in the applicable law, and the contract shall be subject to applicable law. Where is that your government? Yes. It is sought to be highlighted that the RFP already contained the various detailed clauses regarding security and protection of data. It is further stated, paragraph, that, then quote from paragraph 3, this yellow flap, however, having regard to the contentions raised, copy of the draft agreement is produced up to bracketed portion. Paragraph. It is here, madam. Yeah, it is. However, so then the respondent bank has further stated that the reverse auction process has concluded on 25/10/14 And as per the clauses of the RFP, the award of the contract is likely to be given to the three service providers in the ratio of 50, 30, 20 amongst L1, L2 and L3. It is stated that three bidders named Messrs. Versatile Card Technology Private Limited, Messrs. Madras Security Printers Private Limited, and Messrs. IN Desk Solutions Global Limited have been selected in that order as the successful bidders. Paragraph. A specimen copy of the draft contract agreement is produced on record along with the application at Annexure 1. Full stop. Learned Senior Advocate Mr. Nagananda, paragraph. Invited attention of the court to certain clauses which are now incorporated in the draft supplementary agreement. Full stop. Clause 24, paragraph. Clause 23.4 ensures that there will be a compliance of all applicable laws, including the provisions of the Information Technology Act 2000. Then below that, Code 23.4. Full stop. As per clause 20, paragraph. As per clause 23.5, the compliance of data protection laws is mandated for the service provider. Then again, Code 23.5. Full stop. The data protection laws are elaborate. The idea of data protection laws, inward comma, is given in clause 23.6, then Code 23.6. Full stop. Learned Advocate Mr.
Aditya Chatterjee.
Aditya Chatterjee, appearing for Learned Senior Advocate Mr. Jan Chinnappa, however, insisted that the clause in the supplementary agreement now proposed, though takes into consideration the compliance of the provisions of the Information Technology Act 2020 by the service provider, it has no clause regarding the data processing.
The Information Technology Act in the data processing agreement.
And there is no, and the data processing agreement is not contemplated.
Is not contained in it.
Is not.
The reference to the IT Act is not contained in the data processing agreement.
The agreement does not contain the data processing agreement. Full stop. The court finds that in the draft agreement, a specific clause is provided regarding data processing agreement, which is clause 24. Then quote clause 24. All clauses are at page 18 and 19. Paragraph. Not only that, paragraph. All the three successful bidders, L1, L2, and L3, above named, have filed their affidavit. Identically worded, which reads as under. So page 23 over paragraph 2. I state that the modifications to the draft contract agreement. One select pura paragraph 2, page 23, 24. Paragraph. In view of above, the court is of the view that nothing further would survive in this public interest petition, the submissions sought to be raised by, the contention sought to be raised by petitioner, even after the above development, would amount to hair splitting of the clauses of the agreement, which is not to be undertaken by the court. Full stop. The court is satisfied that the public interest petition is no longer required to be continued. It is disposed of accordingly.
So deep.
Yes.
Number 10, so writ appeal matters to Venkatesh HN.
Yeah, for respondent 2 and 3, my lord, the
This
papers
is the
furnished
matter.
are incomplete.
Somebody asked for time, same matter?
No, I didn't ask, my lord.
No, this is
But
not it.
now, my lord, I am asking for time because, my lord, the papers which are furnished, my
Time.
lord, is incomplete. Let them furnish.
At the
a full
request
setup.
of learned, the appellants stand out.
Respondent.
Respondent.
They have complied the office.
12th February, next.
So number 11,
My lord, I appeal for the
Chandrakant Sargule.
appellant, my lord. At the outset, my lord, my submission is that as per the ground number 1, my lord, the connected means writ appeal number 257 of 23, my lord.
Writ appeal number?
257 of 23. By the same institution, but by the society, as against individuals, my lord, is pending before the honorable court.
It was stated that the present writ appeal may be listed with connected writ appeal number 257 of 23, ordered accordingly.
My lords, I'm appearing on behalf of the caveator respondent, my lords. No stay may be granted, my lords. We're ready to argue the matter as early as Wednesday, my lords. The matter has gone in our favor both in the tribunal as well as in the writ petition, my
Both
lords.
may be listed
About
on.
32 employees are affected, my lords.
Both,
Stay may not be
both-
granted.
We have not obtained any
both
interim
appeal
order.
may be listed on
Wednesday, my lords.
13th January.
Please.
Next.
So number 12, to Rajeshwar PM.
For the appellant, my lords. 12 and 13 are similar matters, my
Delay.
lords. First matter, there's delay, my lords. Second matter, there's no delay, my lords. Matter where, my lords, the issue whether central government is the appropriate government or the state government.
We'll issue notice in both.
Yeah, for respondent number one,
Returnable on
Lords,
February 17th.
lords, the
Next.
second matter, my lords. The authorities reserve the matter for our order, my lord, on the basis of the remand order, my lords. The second matter, the authority to whom the matter is remanded has reserved the matters, my lords. Therefore, any chance that he may proceed to pass orders, my lords.
So what can be done?
Therefore, my
Early,
lords,
get a early date, 11th December, chalo. 11th December. Yes, next. Some toll plaza is there. What, nothing to be done with the courts. Next.
Number 14,
The matter is being heard before the learned single judge. Discussing.
Yes, what do you say?
My lord, the challenge.
The challenge is in respect of an order passed by the authorities stating that the resumption of land is for the resumption of land after a long delay, application is filed. Now, in view of the Amendment Act, there is no limitation at all. Now, the only question is whether delay and laches, which has already been declared by the apex court, has to be followed or not.
Now it is decided by one of the.
Yes.
Learned single. judge.
Matter is being heard, my lord, before the learned single judge.
No, already decided about.
Already decided, my lord.
Justice Dixit has decided.
Lord, yes, Lord, he has kept open the issue regarding the challenge, my lord. Page 13 may kindly be
Judgment of this honorable court, my lord.
seen. Page 13 may kindly be seen. Class H, my lord. Regarding the validity, my lord, the issue has been left open.
Only rider is subject to the result of the constitutional validity or otherwise which is before the learned single judge.
That is being
Page number 7.
Read it, what is held?
Plus para C, my lords, page number 20, page number 7, my lords. Para C, my lords, page number 20, page number 7. The waivement submission of Lordnet Council for the appellant that Act number 30 of 23 as amended provisions of section 5 of the 1970 Act by adding clause C and D to subsection 1 of the said section. And therefore, the concept of limitation and delay has to remain miles away. These few clauses read as under, my lords. This is extracted, my lord. Next, para D, my lord. The amendment act is made applicable with retrospective effect is only a duplication of existing legal position. Such duplication happened even in the English legislative history. Hardly needs to be mentioned. The question of delay is a.
Laches is a relevant consideration.
Yes, ma'am.
Even if the delay goes to with limitation, the laches is a different concept. So in every case, we have to see now that whether there is a reasonable ground for delay.
Individual
Yes,
case.
individually.
Yes, yes,
Individually.
yes, that is the problem,
The first case is 12 years, so outrightly appeal is dismissed.
please.
To give the
But
list of
in some cases, also on merits, it has been decided. Also on the merits stating that PTCL Act is not applicable.
why?
To the scheduled property, PTCL Act is not applicable, and also on the ground of delay, both is.
Bench has held that, my lord, this is duplication of the old act. And also held that, my lord, amendment is brought to defeat the, my lord, verdict.
Pull out one by one. Take up one by one.
Please.
Question number 14. Mr. Saravana, yes?
Not, sir, this is
12 years still.
12 years by grantee, my lords. This is by, appeal is by grant. That's why taking up this appeal, my lords, will also prepare to see the interim orders dated 24/8/23. Interim order came to be granted in the light of the amendment to the so this issue is pending consideration, my lords.
Dismissed.
It's only one, my lord, submission is, my lords, now by virtue of amendment, a substantive right has been created in favor of the grantee. Now, that will take away even otherwise if there is the provision
It's
and,
only on the ground of laches.
but now, my lords, amendment says, my lords, it's no delay.
Amendment,
pending.
amendment.
Act, my lords, amendment, now amendment brought to the act says, in respect of wherever the petitions are pending, delay is not applicable, my lords.
Please amend.
Amendment to section 5, my lords. Notes in the orders dated 24/8/2023, it's called out, my lords. May I read, my lords?
Order dated
It's 24/8/23, my lords.
24/8 in this matter.
Yes, my lords, first matter.
24/8.
Yes, my lords. Learned counsel for the appellants invites our attention to the amendment of section 5 of Karnataka Scheduled Caste and Tribes Provision of Transfer of Certain Lands, Amendment Act 23, and then to clause C and D of section 5 of the Act. Amendment of section 5 in the Karnataka Scheduled Caste and Scheduled Tribes Provision of Transfer of Certain Lands Act.
So that is interpreted now by Justice Dixit.
That's interpreted, my lord. The validity has not been gone into, my lord. Interpretation
That
has
is
taken
pending
place.
consideration, not-
Interpretation has
We are
taken
not.
place.
Notice validity of the act is pending consideration before the learned single judge in one of the writ petition.
So delay is a concept nearer to limitation. Latch is independent, independent concept. If somebody has come after so many years, it is, they are guilty of, litigant is guilty of latches.
No, but this says notwithstanding anything contained in the law, there shall be no limitation to invoke the provision.
Where is that?
Not so class D, my lords, of the amendment, section 5, class 2.
That is what said that limitation is delay, latch is a different concept. Latches is different than
Limitation.
delay and limit. That is what Justice Dixit is rightly distinguished.
And then, my lords, the amendment brought will not any subserve the object of the act, my lords. The amendment that is brought, my lords,
So that is pending before the
single
single
judge, my
judge.
lord. Not still such time, my lords, my petition may be kept
Cannot-
pending. My appeal
cannot-
may be kept pending, my lords, still, sir. My appeal may be kept pending because this is by grantee. My lord.
We are dismissing it without touching the
Very well moved.
aspects of consent.
Validity of the amendment, please.
So. So 14 is dismissed.
Lords, if the validity of the act is upheld, my lord, then I may have a chance to revive this. The act is upheld, my lords, then, my lords. The act is, amendment act is upheld. Then, my lords, the.
Even then, we'll say the parties will abide by the validity, bound to be. But in fact, this judgment takes care of the aspect of validity also indirectly.
Even assuming it is upheld.
This judgment. So 14 is dismissed. 14.1.
Says 7.5 years delay, my lord. The property is within the limits of city, BBMP. Now last is agriculture nature, my lord. They have not acted, the buildings are come up with the, my lord, developed area, my lord.
Delay is 7.5 years, my lord. There is a Supreme Court judgment, Satyan versus Deputy Commissioner.
In the limits of city, last is already long back is last is agriculture nature, my lord. The buildings are come up with it, they have paid taxes also, my lord.
On a different ground. What is section 4 into bracket 2? Yes, what do you say?
My lord, restoration application is filed in 7 years, my lord. There's a Supreme Court judgment, Satyan versus Deputy Commissioner, my lord, where it clearly says, my lord, delay of 8 years filing the restoration application is. Kindly see the judgment.
No, this transaction is after the commencement of the act.
Please, my lord.
Therefore, it by
But
section
the
4,
permission, according to the act, the permission is required, my lord.
4.2, that is the reason. What do you say about it? How do you assail it?
This is the last is agriculture, developed area, my lord, is the last is agriculture. nature,
That is
long
not
back,
the
my lord.
question. The transaction is after the commencement of the act.
Yes, please, my lord.
So subsection 2 of section 4 prohibits such transfer. It is
Only
up
my
to-
think is developed area, my lord, is already is building.
No
come up, it is
person
the
shall
last-
after the commencement of this act transfer or acquire by transfer or any granted land without the permission of government.
The
In
paid
view of,
taxes.
in view of the breach of 4.2, the learned single judge dismissed the petition. What is wrong in it?
This is within limits of city, my lord, the last is agriculture, that my, they paid betterment charge also, they paid taxes also, my lord, that's what, my lord.
Yes, find out an argument for it. Any provision which helps you in the act?
In short accommodation, we will argue. In short accommodation.
You find out your. So this will be segregated to be posted on 10th December.
Motion ಆಗಿಲ್ಲ.
Meanwhile, madam, I'll permit me to submit a judgment, my lord. Put-
10th December at 2:30. You find out an argument for you.
Yes, please.
Yes.
Two of 2021.
Other same connected.
Same. So same order.
Number 14.3, writ appeal 552 of 2022.
So delay,
To Sheshadri NS.
delay of 88 days.
There is 88 days delay, my lord.
Any private party is there?
No.
Private respondent?
No, my lord.
No, or learned advocate, so and so, and learned additional government.
88 days delay there. my lord.
So Harish, for the respondent state and its authorities, this application is filed seeking to condone the delay of 88 days, which is occurred in filing the writ appeal. Paragraph, the accompanying affidavit explains the passage of time leading to delay as aforesaid. Full stop. The grounds make out sufficient cause. Therefore, delay of 88 days is condoned. Application is allowed. Writ petition may be listed on 11th of. It may be listed on 10th of December at 2:30.
14.4, Mr. R. Gopal.
For the appellant, my lord, in this case, private parties are respondents 3 to 7, my lord. They have not been notified.
Not been notified. Notified means? Notified means
Notice is not,
notice not served.
not. Course, 56 grant, my lord. The act came into force in 79. First sale was in 84, my lord, 1984. Second sale, my lord, in favor of contesting.
Delay of 30 years dismissals.
That amendment, my lord,
Amendment will deal with.
yes,
It is already argued in the first matter.
and
Suppose 579.
Sir. Say number 14.5, sir, writ appeal 110 of 2023, Mr. Shivaswamy. Writ appeal 110 of 2023, Mr. Shivaswamy.
Service is in compliance. Who appears?
Service is not complete.
Shivaswamy.
25 years. Nobody is there to be listed at 2:30 on 10th of December. 25.
14.5, writ appeal 352 of 23, Mr. Gangi Reddy BV.
Live.
Present respondents. 68.
Here, what is the ground of dismissal of the appeal?
The dismissal of the rate petition, my lord, it's only on the ground that, my lord, that land was resumed. But in the meantime, the land was acquired by the KIDB. So with regard to that compensation, my lord, it is there. That we being the LRs
Should be
also
required
filed
for benefit of KADV, compenses payable, right?
to the
concessions.
purchaser, my lord, it is ordered. That I am also one of the legal heirs of the original grantee.
To be listed on 13th December.
Obliged.
This is a different subject, different point arising.
Number 14.7, writ appeal 748 of 2023, to BS Vishwanath.
Appear for the appellate, my lord, and the notice with notice of second, fourth respondent and the fifth respondent, it is not served, my lord. And all the other respondents are now they are represented.
Dismissed, 14 years.
I have already paid the process in the office.
No process is negotiated. We are dismissing it at the admission stage.
14.8, writ appeal 879 of 2023, Mr. K. Abhinavanand.
Right. Respondents 4A and 4B, first time notice was not served. I've furnished the process for the second time and notice is issued from this honorable court. And earlier, my lord, I was permitted to take notice on the learned advocate who was appearing for R3 and R4A and B before the honorable single judge. The learned counsel, Sri Rajagopal Nadu, my lord, he did receive the copies of the appeal on behalf of R4 and R4B. And whereas he has filed Wakalatnama in this appeal matter for R3 only, and however furnished first process to R4A and 4B and it is issued. So, my lords, so the memo dated 19/6/24 may kindly be rejected in view of the first process furnished to bring the respondents 4A and 4B on record.
to have an inspection of the land.
Said, at 2:30 on 11th December. It's a different decision.
Number 14.16, Mr. Subramania HV. 14.16.
For appellant in this case, my lord. Praise time, my lord, senior, due to senior
Little louder. Little louder.
For appellant.
Will dismiss on the ground of low voice of the advocate.
13 crore discount. 13 crore.
Yes, what do you say?
Praise time, my lord.
Why? We are taking up each and every matter now. Why do you want time?
Senior is in out of session.
Senior is not there, to be listed at 2:30 and on 10th of December.
Number 14.17, writ appeal 1023 of 2023. Mr. B. Ramesh.
The grant is writ appeal, my lords. Grant is of the year 1979. My lords, after the act coming into force. 15 years is in non-alienation clause, my lords. My lords, first sale, the GPA is in the year 1992. Prior to the, my lords, 15 years non-alienation clause, which is within 92 or 15 years, my lord. Sale is 94, my lords. Of course, the Assistant Commissioner has ordered for resumption of land in favor of the grantees. My lords, the Deputy Commissioner reverses the finding. Lords, after the act coming into force, my lords. That issue, my lords, now the 2023, my lords, the new notification is in under challenge.
Section 4(2) will apply.
Yes, my lords. Because, my lords, now if my lords, the land is granted prior to the act, my lords, if the sale is taken place prior to the act, my lords, naturally, my lords, there should be a permission.
Act came into force when?
1979, my lords.
Date.
My lords,
1979.
yes, my lords.
And this,
My lords, this
transaction
grant is after the act, my lords.
Date
My lords, 3/7/1979.
3/7/1979.
Yes, my lords. 15 years non-alienation period, my lords.
No, transaction is 3/7/79.
My lords, transaction is 94, my lords.
Transaction is 90.
Yes, my lords. 9/12/94.
9/12.
Yes, my lords. That issue, my lords, whether the act applies to subsequent grants is in question, my lords.
But the delay, let the legislature will remain same.
My lords, the delay, my lords, that is, my lords, if for the new, my lords, amended act, my lord, amendment of section 4 is also been questioned, my lords. That has to also be, should be seen, my lord.
See, the division coordinate bench has made a distinction between delay and laches. Even if there is no delay, this is liable to be dismissed on the ground of laches.
Lords, now, my lords, whether, my lords, the
Irrespective of that amendment which does away with the limitation aspect, ground of laches will remain.
My lords, now that judgment, my lords, Manchegoda's judgment is there, 1994 judgment, my lords, where the constitutional validity of the act is in question. Where, my lords, that
We are not touching,
my lords, that
dismissed.
because, my lords, the 2010, much of them.
Number 14.18, writ appeal 1026 of 2023. Mr. Siddhappa PM.
सब में आपको
Kindly permit to substitute service, my lord. R3.
25 years.
Substitute service.
Right cannot be set at not after 25 years. Dismissed.
Number 14.19, writ appeal 1037 of 2023. Mr. Egde Ramakrishna.
My lord, the grant is 1963, my lord. The 64 is a sale, my lord. Assistant Commissioner order is, my lord, Indian 1993. AC denied to restore the land, my lord. But only thing is, my lord, the sale was done within 1 year from the grant.
25 years.
Non-alienation period is 15 years.
The original grantee has initiated the proceedings after lapse of 25 years. Dismissed.
Silver 14.20, Mr. Subramani HV.
For appellant in this case, my lord.
Respondent
Price time, my lord.
said, delay, my lord.
In 1 year granted time, here is what to do.
And the grant is offset, my lord. There is no pre-grant or reduced price, my lord.
You have to travel in same boat, Mr. Dismissed.
Number 14.21, Mr. Murthy K. Mr. Murthy K, 14.21.
Yes, you are appearing for respondent.
Yes.
32 years. 230. To be listed, 230 today.
Number 14.22, Sandeep VC. 14.22, writ appeal 1058 of 2023.
Inordinate delay of 39 years. Who is there? 230.
Number 14.23, writ appeal 1077 of 2023, Mr. S.V. Prakash.
My lord, I appear for appellant. My lord, the grantee's appeal, delay of 59 years.
59 years.
59 years.
Record breaker. Dismissed. Sorry.
Fourteen point 24, writ appeal 1089 of 2023.
For
Mr.
appellant
Sandeep.
in this matter. It's a grantee's appeal, my lordship. It's a 12 years delay within time. 12 years delay, man. Within 12 years, my lord. Within 12 years, my lord.
So what? 12 years is limitation?
Please,
Where from you get it?
I will argue on the next date of your, with citation, your lordship. I will argue on the next date of hearing.
Next day will argue.
May have 13th,
10th
meantime, notice may be
December
ordered.
at 2:30.
Notice may be ordered.
No,
4 and 5 notice.
We
has
argue
been
on
not served.
10th December at 2:30.
14.25, writ appeal 1123 of 2023, Mr. Sridhar.
My lord,
appear for the appellant in this case, my lord. May I tender profound apology, my lord. May I request for a short accommodation, my lord. Next time I'll argue, my lord. I have certain citations to be pressed the course of my arguments, my lord.
The legal heirs of the pre-existing, legal heirs of.
Legal heirs of the grantee, my lord.
Grantee have
Yes.
no pre-existing right, can maintain the restoration proceedings after 27 years. Sorry, dismissed.
My lord, I have Amarendra Singh's case, my lord, which I rather pressed into service while I argued before the learned single judge, my lord. Today, my lord, since I have underwent surgery for my right eye, I was unable to read the file. My lord. That's the reason.
Listed 230 on 10th December.
Much honest.
So 14.26, writ appeal 1141 of 23. Mr. Nagaraja,
For the appellant, my lord, the matter has to go back to my lord, the learned single judge. For the reasons, my lord, the grantee was dated on 10th of May 2020. And the order of the learned single judge on 13/6/2023, my lord. It's a nullity in the eye of law. That's the reason, my lord, the matter has to go back to the learned single judge.
There is a gross delay of page paragraph 5, 30 years in initiating the action.
But my lord, the nullity for the reason, my lord. The grantee dated on 10th of May 2020. The writ petition disposed of on 23, my lord. It's a nullity in the eye of law. That's
In all
matter has
these
to go.
cases, you will get the order in the next week because we are passing several orders. Copy will be available in the next week. After 5th, it will be available. And then that, separate. Argue on 11th of December. 2:30.
So number 14.27, writ appeal 1149 of 2023, Mr. L. Srinivas Babu.
Please,
There is delay of more than 20
in
years.
this case, there is a 33 days delay in filing the writ appeal, my lord.
That will,
There is delay of more than 21 years.
Kindly
IA
Making
number,
application for restoration of the land.
IA number 23 of, who appears, but the private parties are there.
Appearing for private party, there is delay of more than 1 year, 21 years and above in making the application for restoration of land by the.
It's a 21 years delay, my lord, and there is a delay in.
You are for private party?
Yes, ma'am.
All are there?
On behalf of the purchaser.
All the private parties you are representing?
Yes, yes.
Or learned counsel of the respective parties, IA. Delay of 33 days is explained in the accompanying affidavit. Sufficient cause is made out, delay is gone down. Writ appeal may be listed 10th of December at 2:30.
But there is delay in filing the application by for restoration itself by the legal heirs. More than 21 years is delay is there. Maybe around 10, 12 months. That I will make. 14.28, writ appeal 1225 of 2023, Mr. Nanda Reddy PN.
Respondent number 3, madam.
14.28.
Petition is allowed. $230.
14.29, writ appeal 1246 of 2023, the Karthik C. 14.2.
I appear for respondent number 4.
Years.
Delay.
2:30.
14.30, Writ Appeal 1263 of 23, Mr. Siddhappa PM.
Appear for appeal.
Okay, respond for.
Yes, Mr. 18 years and 9 months.
Weeks time. Senior,
Senior,
senior has another for weeks time.
senior will come at 2:30, then 2:30. 2:30, 2:30.
Number 14.31, Writ Appeal 1284 of 2023, Mr. Ramesh Kumar RV. 12.31,
Like. $42 delay. $230.
so 14.32, Writ Appeal 1354 of 2023, Mr. Sampath A. 14.
Respondent number 3 and 4, my lord. There is a delay of 19 years, my lord.
You have a respondent.
Please, my lord. 3 and 4, my lord.
Where it is stated in order, 19 years.
That sale date in the year 1996, my lord. Application filed on 2015, my lord.
Two 2002 order was passed.
2000, in the year 2002, my lord, respondent number 2 initiated summata proceedings, my lord.
The petition was filed in.
Yeah.
2:30.
Please, my lord.
Writ Appeal, seal number 14.33, Writ Appeal 1370 of 2023, Mr. Amresh N.
Waiting for respondent. 4, 5, 7 and 8.
Mr. Amresh N. 14.
I'm appearing for respondent number 4, 5, 7 and 8, my lords. Lords, in this matter, my lords, the land which is in question, my lords, it is not comes under PTCL Act, my lords. The land was granted under the Grow More Foods Acts, my lords.
To be listed on 11th December at 2:30. The 12th December at 2:30.
What's up, guys?
Seal number 14.34, Mr. Sampath A. 14.34.
For caveat for respondent number 1 in this case. No need of service of copy, my lord. We will appear before. Next date we will argue the matter.
It may be.
Provisions not applicable. To be listed at 3:30 on 11th.
Number 14.35, Mr. Prabhakaraya, NV.
Grant is appeal, my lord.
Respondent, my lord.
There is a delay of 270 days in filing the appeal, my lord.
23 years. Nineteen 93 sealed, my lord. Sealed it, my lord. The proceeding is initiated in 2016. 23 years delay, my lord.
24 years, too long the period to come down. Amounting to petition without, by purchase.
There is a violation of the conditions of the grant.
Who is
my
the
lord.
petitioner?
Much up.
So 14.36, writ appeal 1423 of 23, Mr. Prasanna VR.
Appealing for a respondent, my lord.
Correct. 1955 grant, my lord. 1991 is the first sale deed. Though the order of the deputy commissioner is in 2014, there was a delay by the petitioner approaching the single judgment, learned single judgment.
Sorry,
Possession is with the appellant.
20 years still.
More than 20 years.
14.37, writ appeal 1437 of 23, Mr. Bharat
Yes.
D. But
Appealing for a respondent 5 to 13, my lord. 28 years delay, my lord. Grant in the year 1962, my lord. Sale was in 27/1/1982. Application filed on 3/5/2010, my lord.
24 years, 25 years.
28 years, my lord.
230.
Not so much.
number 14.38, Mr. Prakash KV, 14.38.
But I appear for the respondent number.
152 days, 152 days delay in filing the
There is
appeal.
a delay of 18 years, my lord. Para 6 of the learned single judge order. Paragraph 6 in page 18. 17, in page 17,
18 years.
18 years.
Dismiss, no, delay is not counted.
Dismissed. So 14.39, Mr. Prabhakarya NV.
For the grant is appeal, my lord. There is a delay of 350 days, my lord. Permit, I will, next date I will address the arguments on merits.
Delay. There is a 11 years delay, my lord.
Pardon?
11 years delay.
Application for resumption of land was filed after 20 and 17 years reflection. Place lapse of 17 years from the date of the second deed serves.
Para number 4, my lord. Para number 4 of the impugned order. Page number 23.
But from the date of second.
17 years delay in for restoration application.
Hmm?
For restoration, it is 17 years.
Restoration application.
Fourteen 2014, my lord, the application has been made. And grant is on 22/9/1988, my lord. And sale is on
1994, that is on April 22nd, my lord.
Restoration is 2014.
Dismissed.
Acha.
14.40, writ appeal 1487 of 23, Mr. N.S. Butt.
Hearing for grantee, appellant.
14.40.
30 years delay, my lord.
30 years.
30.
Yes.
Delay in appeal, filing appeal may be condoned. Delay in filing appeal,
Delay will not condone because there is no merit in the.
please,
Delay not to be condoned.
please.
On the ground that the appeal itself is without substance.
Please.
Fourteen point 41, Mr. Writ appeal 1619 of 20.
Preparing for appellant.
Mohan Kumar D.
Seek short accommodation, my lord.
I appear for
Because, my lord,
respondent
senior
number
has been,
5, purchase on 37 years delay.
senior has been hospitalized, my lord. Senior has been hospitalized due to spondylosis problem, my lord.
To be listed at how many years? 30?
37 years. Para 6 of the learned single judge order.
At the request of learned advocate, so and so, on the ground that the senior advocate who will be, learned senior advocate will be conducting the appeal is hospitalized. 10 to 10th December at 2.
So 14.42, writ appeal 1624 of 23, Mr. Venugopal MS. 14.4.
The grant is writ appeal. Grant is writ appeal, minutes. Page 36, minutes. The authorities have held in favor of the petition appellant, minutes. The learned single judge interferes with the order on the ground that there is 37 years delay, minutes, in
14. 14.
page 36, minutes, para in
By purchase.
para 11.
Para
11, minutes.
11. $37 years still. Right. Dismissed.
14.43, writ appeal 51 of 2024, Srinivas.
Kindly pass over, my lord. Kindly have it on 230. 230.
What is it about? Same? $230?
230.
230. Number 14.44,
Blood sign for the.
Monesh Kumar KB.
Case. 1932 is the grant please, for three eliminations have taken place. 2019, please, they have approached the deputy commissioner.
Pardon?
1932 is the grant in favor of our grandfather, that is appellant's grandfather. And the 2019, they have approached the deputy commissioner. Order of the deputy commissioner. page number 177. Only on the premise, please note that there has been a delay. The Deputy Commissioner Millards has dismissed it. But pursuant to which, please Millards, even before we approach the learned single judge, the amendment has taken place, Millards, to section 5. And there is no question of any delay, please. Matters. Limitation, may I pass on the amendment probably?
Come on, 11th December. 11th December to.
Wait.
So 14.45,
19 years.
277 of 24,
19 years delay.
SV Prakash.
19 years delay,
Page number 28,
Very-
para number 6.
para 6.
Very fair. Why it was only 19 years? Why not 20? This is by purchase.
Purchaser, this is a grantee appeal, my lord.
The date of purchase is
Appeal by purchase.
appeal by grantee.
Grant.
Read by purchase.
Original grantee, my lord, sold in the year 1991. My lord, delay in filing the appeal, my lord.
Delay is there. Delay will not count.
Please dismiss. Oblige.
The appeal accordingly. Okay. Dismissed. Again, we are telling that the orders will be available after 5th. We try to give in this week, but orders will be available after 4th or 5th.
Very well, my lordship may,
Several matters are disposed of, yes.
the issue of validity, my lord, sorry for repeating, my lord.
Not touching the
Please.
things that we observe in.
Please.
The order in the serial number 14 will be the
On
main
the-
order.
On the issue
What
of
are the-
latches, my lord, the distinction has been made.
This. Writ appeal 15 of, serial number 15, writ appeal 971 of 24, state appeal.
Lord, I appear for the appellant, Lord. My lord, the respondents 2 to 10 were unserved, my lord. All the Lord, all the respondents against whom relief was sought, my lord, have been arrayed as, are before your lordships as appellants, my lord. So I'm filing a memo, my lord, to dispense service to respondents 2 to 10, my lord.
Dispensing with the notice or deleting? You're deleting those respondents or dispensing with the notice? What
Notice
is the-
may be dispensed with, my lord. We'll file a memo to that extent.
So it is amounts to deleting.
My lord, respondent number 2 to 10, last occasion, lordship directed me to take formal notice here, my lord.
Respondent now. 2 to 10 you accepted the notice, 2 to
I have
10.
taken formal notice on behalf of respondent number 2 to 10, my lord. Yeah, now the memo is being filed, my lord, seeking dispensation of notice to them. They are agencies of the government, my lord, they are officers.
All right, we'll look for the-
Returning officers, my lord, we are sailing with the appellant government, my lord, in this.
So all respondents are now served.
Yes, my
Or,
lord.
or
Respondent number
representative.
11, my lord, Milanet friend of this.
My lord,
These
one
are-
short
yes.
submission, my lord. Just one short submission, if lordship permits.
Yes.
Both of us now have filed a synopsis, my lord. And my additional affidavit, where I had produced certain documents, the first respondent has also considered that in their synopsis, my lord. All that I want to say is every fact has been disputed by them in the synopsis to the documents which I have produced, my lord, which itself goes to show that it's a matter that needs to be adjudicated in another forum and not in 226. That's all.
We'll consider. Yes.
That's
Resort for judgment. Give
Great.
appearances.
Lord, there is a connected contempt matter, my lord.
Contempt will go with
That,
it.
yes, my lord, we have already submitted.
Both reserve order in both appeal as well as contempt.
Yes. So commercial appeals, seal number 16,
Appeal for appellant, Your Honor.
Mr.
Sir.
Prasad.
Yes, please. Your Honor. The only deficient fee of rupees 3,000 is a government corporate body appeal. For that, I am ready to pay that within 1 week. Already I have given a, within 1 week we have to pay undertake. Deficient court fee, deficient court fee. We are already paid 3,96,000 as per the,
Fee shall be paid within 2 weeks.
please.
Please.
One submission, they have to file an execution, we have to stay maybe, sir, this is a tender of the work, we have to, the difference of the amount.
Unless the court fee is paid within 2 weeks.
The one,
appeal shall
as per
stand
my
auto-
lordship, as
Unless
per office objection.
permit us to dictate the order. You are asking for stay without payment of court.
Only 3,000 then.
So court, it is admitted position that the entire court fee is not paid in this appeal. The appellant is given time for 2 weeks to pay the balance court fees. If the court fee is not paid on or before 15th of December, on 10th of December,
Alla,
the
15th ಇರ್ಲಿ sir.
appeal shall stand on automatically dismissed without reference to or order of the court.
ಅಲ್ಲ, 15th, December 15th, is already given a letter, it's a
15th.
government that is,
15
it's
December.
not a private party, much obliged.
Number 17. To Varun, yes.
My lord, I appear for the appellant.
My
Lord, a award passed on the basis of an alleged settlement that had been arrived at between the parties has been questioned, my lord. The award holds, my lord, that there is an earlier settlement agreement and therefore, my lord, payment is required to be made on the basis of that settlement agreement. That was questioned, my lord, before the commercial court under section 34, which has been dismissed. As against which, my lord, we are now in appeal before your lordships under section 37 of the Arbitration and Conciliation Act 1996. My lord, before I trouble your lordships on the facts of the case, which I will do, my lord, if it's necessary, may I just point out your lordships, my lord, the order that has been passed by the section 34 court and the judgment of this honorable court, my lord, and your lordship may kindly see if that order passed by the section 34 court passes the muster of the law laid down by this honorable court. My lord, please be kind enough, therefore, my lord, before I go to merits, because if I am right on that point, my lord, I don't think I'll be justified in taking your lordship's time on the merits of the matter. If I'm not able to convince your lordships on that point, my lord, of course, my lord, I'll take your lordships to the merits. My lord, please be kind enough to see the order, my lord, which your lordship will kindly see at page number 36.
Page number?
I'm sorry, my lord. Kindly see page number 49. My lord, I have prepared a synopsis. If your lordships will permit me, can I place it, my lord? It is on, now. That's it, yes, May I trouble your lordships to kindly see page 3 of my synopsis, my lord. I will go to the judgments later, my lord, if necessary. May I trouble your lordships to kindly see para 10. An analysis of the judgment passed under section 34 of the Arbitration and Conciliation Act 1996 is set out below for the kind consideration of the Honorable Court. My lord, what does this order contain without meaning any disrespect to the learned commercial court, my lord? Para 2(3) is reproduction of facts. Para 4 is reproduction of the grounds of challenge. Para 5 is reproduction of the objections to the ground. 6 and 7 is reproduction of the grounds of challenge. 8, reproduction of the contents of the award. 9, reproduction of the award. 10 and 11, reproduction of the law, judgments relied upon by the appellants. 12, formal content. 13, 14, points for consideration and findings. 15 to 20, mention of legal principles for deciding a challenge under section 34. 21, 22, reproduction of the grounds and contents of documents. 23, 24, reproduction of arguments of both sides. Para 25, reproduction of the order of this honorable court in CMP number 238 of 2018. That is the appointment of an arbitrator, irrelevant for the purpose of section 34. 26, recording the fact of finding in the CAP and that the same has not been challenged. 27, mention of reliance upon precedents. 28, reason for rejecting the ground for non-exhaustion of pre-arbitration discussions, again irrelevant, my lord. 29 to 34, reproduction of the grounds and arguments on non-arbitrability. 35 to 36, reasoning and finding on the ground of non-arbitrability. 37 to 38,
reproduction of the grounds and arguments on the settlement agreement. 39 to 40, reasoning on the point of insufficient stamp duty and recording the finding of the arbitral tribunal irrelevant, my lord. 42, application reliance upon precedent to the issue of interest. Then, my lord, 43, vague reference to principles of deciding a challenge under section 34. Now, my lord, please be kind enough to turn to para 43, my lord. This is all that there is in it. Please be kind enough to turn to para 89. Page 89, my lord, I'm sorry. Paragraph 42. I'm sorry, please be kind enough, my lord, to turn to page 87, para 39 for a minute. After all this, on a perusal of the award, I do not find any objections raised either by the petitioner or the respondent regarding insufficient stamp duty of the settlement agreement. Learned arbitrator has held in para 49 of the award, that's so and so. On a perusal of the portion of the award, it discloses that the learned arbitrator has directed to pay stamp duty payable and as per Stamp Act. I do not find any intervention. Then, my lord, 41, the learned commercial court talks about interest. Had no discussion, my lord, with respect to, kindly see para 36 at page 84. If at all, my lord, there is any application of mind, even remotely, it should be in para 36. Otherwise, there's nothing else in this order. In view of the above decisions, I do not find any intervention is required against the findings given by the learned arbitrator on preliminary objection. Hence, on this ground, the award cannot be set aside. Lord, what is? And there are substantial grounds that we had urged. And your lordship may kindly now see the judgment of this honorable court, my lord, at page number 36. Is that correct?
Yes, sir.
36.
Now, page 85.
Respectfully, my lord.
Page 85.
Yes, my lord, I'll read that.
From third line, the learned arbitrator further.
But that erred that a commercial, there is all contentions, my lord.
Contention reasoning.
Contentions, my lord. Please see para 37 at the bottom of page 84. The petitioner has taken another ground to the challenge of the award that the learned arbitrator failed to consider that the exhibit P1 was not a document that created a liability and the alleged dues were not payable by the applicant herein to the respondent without any independent evidence being adduced of acknowledgement of any debt or liability. Learned arbitrator further erred. This is all not the contentions. The learned arbitrator further erred that a commercial suit in OS number so-and-so was pending between the parties wherein respondent had claimed a sum of rupees so-and-so from the claimant while passing the impugned award. Hence, the award is liable to be set aside. Further, learned arbitrator failed to consider the fact that the claimant on the one hand contended that the settlement agreement is enforceable and on the other hand contended that the said agreement was a result of inducement by the respondent. Hence, the claimant is entitled for payment. Hence, the learned arbitrator erred in passing the award impugned without holding that the claimant is blowing hot and cold. This is our contention. It is not a finding, obviously, because when you say the learned arbitrator erred, that's what we are saying. And what is the judge saying? Well, kindly see one judgment of this honorable court, my lord, faced in a similar situation. And in spite of this, my lord, this is the way the orders are written. Please see, I'm sorry.
Yes.
Kindly see page 36, my lord, of the same compilation. Faced in a similar situation, kindly see, my lord, my lord, in the same compilation, my lord, if your lordship will, yes, my lord, yes, my lord, yes, my lord.
Page 36.
Yes, my lord, page 36. At page 43. In fact, my lord, I may refer to your lord to page 42. At paragraph number 12 at the bottom. The judgment begins at page 36, my lord. May I read it, my lord?
Here it is remanded.
My lord.
Here it is.
Yes,
remanded.
yes. Your lordship gets that, my lord, at page 47.
There is some substance.
Not at all.
No, not at all.
Not at all.
Let us see.
I'll be able to point out why there is no reason for, occasion for granting reasons. So the matter, a dispute arose. Sorry to interrupt. His Lordship
Of
addressed
course,
me
of
therefore.
course. No, no,
Therefore-
I
I thought I'll not interrupt my.
no.
No, the dispute arose out of an
No,
admitted.
Mr.
written
Raghavan,
agreement
the-
which is
in
not
fact-
disputed.
Once, in fact, law is that when you are concurring, you need not give reason.
That's true. That's also there. And it arises out of a settlement agreement, my lord. There is no dispute. The settlement agreement has not been
There is.
disputed.
That
We
is
agreed to
the
pay me money.
question. In fact, in the grounds,
Settlement agreement.
my lord,
Yes. And that is why he did not honor the settlement agreement. Therefore, I had to come for arbitration.
and then, my
The
lord,
settlement agreement is not questioned. The learned
Of course it
arbitrator
is.
says, this is the settlement agreement. You have agreed to it. You have to pay the money. Pay the money. That's all that happened. Nothing else happened.
Are you disputing that agreement?
of course, none. If you don't,
Not at all. Not on record. Now he may be disputing it. On record in pleadings, never disputed.
on the contrary, the claim statement filed by my learned friend's client gives a go-by to the settlement agreement and says, I want the whole of the money, not the amount that is subject matter to the settlement agreement. In fact, they themselves have given it up. And the prayer in the claim statement is, give me the whole of the money. And therefore, my lord, we took up a specific plea both before the arbitrator as also before the section 34 court that they cannot approbate and reprobate. They can on one hand say that this entire settlement agreement is terminated for whatever reason, good or bad. On the other hand, say, give me money under the settlement agreement. My lord, I may be right, I may be wrong. But somebody must apply their mind to it. No, it's not a case when my lord, they're sitting in appeal. It is a 34 court. Kindly see what this honorable court said, my lord, in very similar circumstances. If I may trouble you not to kindly see, my lord, that judgment of the division bench of this honorable court in very similar circumstances. My lord, kindly turn to page number 36. And if I may trouble your lordship to kindly see page 42 at the bottom. And I showed your lordships the pleading. They have themselves given a go by to it, and the prayer, my lord, is give me the whole amount, not the settlement amount. Because the settlement agreement is no longer binding between us. My lord, kindly see page 42 at paragraph number 12 at the bottom. May I read it, my lord? We have also referred to, may I read it? If your lordship's permit. We have also referred to the decision of the Apex Court, which holds that the scope of interference is confined to specific grounds which are available under Section 34 of the said Act of 1996. It is also well settled that the court should not interfere with an award merely because another view on the facts of interpretation of a contract exists. When a judge dealing with a petition under Section 34 of the said Act of 1996 hears the petition on merits, firstly, he must advert to the grounds agitated at the time of hearing in support of the petition under Section 34 of the 1996 Act. He has to examine whether the grounds urged are available under subsection 2 and subsection 2A of Section 34 of the said Act of 1996. If the grounds pleaded are available under 34 of the said Act, The next step will be to consider each and every ground pressed into service on merits and to come to the conclusion whether the grounds have been established. And then kindly see para 13, my lord. Therefore, it is necessary for a judicial officer dealing with the petition under section 34 of the said Act of 1996 to precisely record the submissions made by counsel for the petitioner in support of the petition under section 34 of the said Act. It is also necessary to precisely record the submissions made by way of reply to the specific grounds pleaded by the petitioner. It is not necessary to make verbatim reproduction of the oral written submissions. The gist of every ground agitated and reply to it by the rival party needs to be incorporated. This helps the judges to deal with every ground urged. Afterwards, what should the judicial officer do? Thereafter, each and every ground will have to be separately considered, not simply say none of your grounds come under the provisions of section 34. It can't be a blanket statement like that without any application of mind. It is necessary for the judicial officer to firstly consider whether the ground agitated is covered by any of the grounds set out under section 34 of the said Act of 1996. If, according to the learned judge, the ground agitated is not available for challenge in accordance with section 34, judicial officer will have to record the reasons for the said conclusion. If he is of the view that the ground agitated is available under section 34 of the said Act of 1996, he will have to consider whether the said ground is established and record reasons in that behalf. Now, coming to the issue of decisions relied upon by the parties, it is not necessary for judicial officer to quote the relevant parts of the said decisions. What is more important is that the judgment should show that the judicial officer has adverted to the ratio of the judgment. Only after adverting the ratio of the judgment, judicial officer can come to a conclusion whether the same can be applied to the facts of the case before him. Thus, while dealing with the petition under section 34 of the said Act of 1996, for arriving at a correct conclusion, judicial officer, as stated earlier, must precisely record the submissions canvassed in support of the petition and the submissions canvassed for opposing petition. It is not necessary to reproduce the submissions verbatim. Substance of the grounds must be briefly recorded. As a remedy of an appeal is available against the judgment and order in a petition under section 34 of the said Act of 1996, recording of the submissions made across the bar helps the appellate court to decide the appeal properly. If the submissions are not properly recorded, it gives scope to an argument that a particular submission was made before the concerned court, but the same has not been considered. If such submissions are made, as per settled law, the appellate court has to relegate the aggrieved party to the same court for making an appropriate application, as the appellate court cannot decide what transpired before the court which has passed the impugned order. In the present case, we find that the submissions made in support of the petition and are not properly recorded. There is cursory reference to only one or two submissions in para 17. As stated earlier, jurisdiction under 34 of the said Act of 1996 is not an appellate jurisdiction. The exercise of jurisdiction is confined to the grounds set out in section 34 of the said Act of 1996. In the facts of the present case, we find that after having gone through the impugned judgment and order, it is very difficult for us to know what were the precise submissions made in support of the petition and for opposing the petition. As the submissions are not properly recorded, learned judge has dealt with the issue in a very cryptic manner, exactly what has been happened in this case. You may write, my lord, it is not the length of the judgment that matters. It is the content that matters. You simply record everything, judgments are quoted. Where I ask myself is the application of mind of the court to the contention, and it's a very important contention, my lord. In the claim statement, the claimant themselves gave up the plea relating to the settlement agreement and then said settlement agreement is not valid. And the settlement agreement records that they had a claim for 36 crores and as part of the settlement, they had agreed for 24 crores. 23 crores. Now, in the claim statement, say, no, I don't want 23 crores. I want the whole of the 36 crores. They were giving it up themselves. Now, therefore, the question was as to whether they were entitled to 36 crores. Now, we took up the plea that you cannot claim on the basis of the settlement agreement as the arbitrator has done because of the principle of approbate and reprobate. You can't say on the one hand, give me the full amount. On the other hand, arbitrator says, I'll give them settlement amount. If they themselves are given the settlement, where is the question? We have taken up this plea of approbate and reprobate in these words. And learned judge Manod records it also. No consideration. And that I thought Manod was a very important point. Because the entire award is based only on the settlement agreement. If I am right in my submission that the settlement agreement cannot be acted upon because they have themselves reneged from that settlement agreement, I ask myself, should not the arbitrator have gone into the question as to whether they were entitled to the 33 crores or not? Nothing is done. My lord, now your lordship may kindly see, my lord. I showed your lordship where they have reneged on the settlement agreement. Please be kind enough, my lord, to turn to paragraph number 8 of the statement of claim, volume 2 of the appeal at page 314. My lord, I put all this in my propositions list, my lord. I'm referring to page 312 of volume 2, which is the claim statement file.
Page
312, 312, my lord.
It is after the award.
My lord,
Claim statement is.
filed before the learned arbitrator. Let us see their case. My lord, if your lordship will be kind enough to turn to page 314. Paragraph number 7 and 8, my lord, according to me, clinches the issue.
Yes.
May I trouble your lordship to kindly see page 314, my lord. Para 7. Upon completion of the work, my lord, in just 2 sentences, we, my lord, the appellant who was a respondent in the arbitration, we had a contract for providing certain services to UIDAI, my lord, which operates the Aadhaar card. We had in turn given it a subcontract to the claimant who is the respondent for your lordships. Now, my lord, kindly see para 7. The dispute is in regard to that. How much money they were entitled to from us. Kindly see para 7. Upon completion of the work, the claimant raised its invoices on the respondent, and as of July 2016, respondent owed rupees 37.60 crores to the claimant. That was their original amount. Then, my lord, pursuant to negotiations, the respondent represented to the claimant that if the claimant were willing to settle for a lesser amount, the respondent would pursue the matter with NIELIT, that is, my lord, the organization which is, my lord, doing the work for Aadhaar, and arrange for expeditious release of the funds so that the claimant would receive the money quickly. Respondent thus induced the claimant to enter into a settlement under which the claimant was misled into agreeing to receive a lesser amount in full and final settlement of its total claim as set out in the settlement agreement dated 15/7/2016. Now, my lord, if they wanted to simply rely upon the settlement agreement, they should have confined their claim to the amount of 23 crores, my lord, which is found in para 9. Pursuant to the settlement agreement, claimant and respondent inter-alia agreed, the respondent shall pay the claimant 23 crores in full and final settlement of all dues owed to the claimant. I will come to the other clauses if necessary later, my lord. Now, my lord, please be kind enough to turn to paragraph number 25 at page 318 at the bottom. It is now evident.
Page
318, my lord. It is now evident that the respondent had all along intended to cheat the claimant by falsely inducing it to enter into the settlement agreement and to consent to receiving only 23 crores as against these dues of 37 crores, 63 lakhs, etc., etc. Then, my lord, just a few lines at the bottom, my lord, about 10 lines on the bottom of that paragraph. The respondent has thus, because of the inducement and false representation, The respondent has thus directly caused the claimant to suffer a loss of 14 crores 63 lakhs 64,791, which the respondent is liable to pay by way of damages for having induced the claimant into entering into a settlement and agreeing to forego a large part of its claim and to settle for a lesser amount. The difference, my lord, between 37.60 and the settlement amount of 23 crores is this 14 crores. If really, my lord, they were relying upon the settlement agreement, then, my lord, they can't now ask for 14 crores. Kindly see the prayer. If your lordship will kindly turn to page 320. They want the full amount of the invoices and give a go-by to the settlement agreement, and the arbitrator now passes an award on the basis of the settlement agreement. Kindly see, my lord, the prayer at page 320, paragraph number 29. In the circumstances, the claimant pray that this honorable tribunal may be pleased in the interest of justice and equity to pass an award, directing the respondent to pay the claimant a sum of rupees 4 crores. I think that they've already got, no? That they've already got. There's no difficulty about that. That's over, my lord. Now kindly see B. Directing the respondent to pay the claimant a sum of rupees 23 crores. That is, my lord, the amount under the settlement agreement. If they really wanted to stand by the settlement agreement, the claim must have stopped there. Now kindly see what they do in C. They give a go-by to the settlement agreement, say, give me the balance of 14 crores. So they themselves gave up the settlement agreement. Now today, the award is passed on the basis of settlement agreement. And in the section 34.
What is the award?
Manat,
The award is for how many?
award is for a total sum.
Amount of
14.
the settlement.
Settlement agreement.
That is all.
That's right.
And that also
That can't be
sharing,
done.
my lord. That also sharing, not the full amount. Sharing, my lord, the amount that came from that NILET, from the government department. In the settlement agreement, we had agreed to share it 60-40. The learned arbitrator says that, yes, this is the amount that has come, and in accordance with the terms of the settlement, you will share it in that manner.
That is it, my lord, that is it totally. Now, the point I'm placing for your lordship is, can an award be passed on the basis of a settlement agreement, which itself is thought to be given a go-by by the claimant? And we kindly see the award, my lord, at page 97 of volume 1. But this point is not considered, my lord. I may be right, I may be wrong. That's a different issue. But I need a consideration before the section 34 court. Hey, my lord, that's the only remedy available to me. I'm not in the arbitration.
You are not disputing the settlement.
Oh, I'm disputing it. Of course, I'm disputing it. I am disputing it too.
What is that?
Well, in my counter statement, I've disputed it. 1 minute. I'm disputing it in the counter. They themselves were, now I'm saying, sorry, you have not done the work to the extent of 34 crores, you're not entitled to the money. Prove you have done the work. Because, my lord, the problem was that my employer was seeking to levy penalty on me for the deficiency in work which they had done. I put it before the arbitrator. Of course, my lord, I'm disputing it. I said, you're not entitled to the money. Prove to me that you've done the work properly. Because I am now being penalized by my employer.
Where is the settlement? Let us see again.
My lord, I'll show you. My lord, settlement agreement your lordship will find is in volume 2 at page 356, exhibit P1.
1 second.
I showed your lordship those clauses. This is to be read as a whole. We need a statement of objections. Before the arbitrator. Statement of objections. Page.
Page?
My lord, the settlement agreement, my lord, is at page 357. And then I showed your lordships, my lord, what is our defense?
357?
Yes. Yes.
In the first volume?
My lord, it is in volume number 2, my lord.
Then you are trying to back out.
No, they were backing out because they are asked for the entire money. My lord, they were asking for the entire amount. Well, they were not.
Right, but today they have not filed appeal.
No, they have not, my lord. But in the claim statement, they were backing out of the settlement agreement. It says, no, I am entitled to entire 37 crores. I am saying, sorry, you are not entitled to 1 penny because you have not done the work.
Today they stand satisfied with the settlement.
There may be settlement. They can't go blow hot and cold. That's the point. They can't on the one hand say, I throw the settlement away. On the other hand, get an award on the basis of settlement agreement. Well, that is against all notions of appropriate.
Why do you want to resile from the settlement?
Well, I want to because I am saying you have not done the work. Now kindly see the settlement agreement. It says so. Well, if the settlement agreement is read, I am saying, I read your claim statement. You are now claiming the entire 37 crores. You are not entitled to any money because you have not done the work. We go back to the situation before the settlement agreement.
Why did you enter the settlement?
No, settlement agreement is conditional. It is conditional.
Where is it?
My lord, kindly see page 357.
Then that might clinch.
Yes, my lord, 357.
357 conditional.
Yes, it is conditional. I've showed your lordships, my lord.
Let us see.
Yes, my lord. May I just, my lord, kindly see the parties, my lord. The parties are the claimant and the respondent. That's, my lord, please be kind enough to turn page 358.
Yes.
We read the whole agreement, becomes so clear, my lord. Kindly see the second paragraph. Whereas, Unique Identification Authority of India, hereinafter referred to as UIDAI, empaneled SOS. SOS, my lord, is the appellant before your lordships, as an enrollment agency which can be engaged by UIDAI registrars for the purpose of enrolling residents for Aadhaar and collecting demographic and biometric details of residents of India. Then, my lord, whereas UIDAI registrars UID Maharashtra, National Institute of Electronics and Information Technology, SCEC Karnataka, NPR, BME for the states of UP and Bihar, hereinafter referred to as the projects. Now, my lord, we are concerned with National Institute of Electronics and Information Technology. Referred to as the projects, awarded work relating to Aadhaar enrollment and creation of National Population Register for usual residents in rural areas, as the case may be, in favor of SOS. SOS being the appellant before your lordship. Whereas SOS and emphasis, my lord, is the claimant, respondent herein. Entered into agreement POs as mentioned in Annexure A with reference to projects with a view to achieve mutual business benefits and capitalize on each other's unique business strengths for successful implementation of projects on mutually agreed terms and conditions. Whereas emphasis has intimated completion of all the projects. So they came and told us that they had completed all the projects. The projects, my lord, are those various projects mentioned earlier. And submitted invoices pertaining to the same in a timely manner. The total receivables to emphasis which remains outstanding as on date is rupees 37.60 crores. Whereas emphasis was intimated by SOS that some closing work and correction works were performed by SOS to deliver the project delivers, and emphasis has acknowledged the same. So, my lord, something which they had to do, we did. And they have acknowledged the same. Whereas, even though the completed work has been submitted to NILIT, and NILIT has so far not evaluated the work in terms of the payables and penalties for any delayed submissions and has not intimated to SOS the final figures. Whereas, in the best interest of the parties have agreed to a settlement subject to terms hereinafter appearing, which will be final and binding between the parties. What are the terms and conditions? If NILIT does not impose any penalty, I will pay you this. It's there, my lord, in the... It's not an unconditional promise to pay. This is a matter to be decided. And now, I'll read the terms of the agreement for your lordship's kind consideration.
So this penalty is now imposed?
Yes.
Imposed.
Let submissions not be made contrary to record. Contrary to record, no submissions ought to be.
And nil
No
it,
recorded penalty.
nil it is still not settled the bills because they are holding it back because of the deficiency of that work. This is what my lord was contended, that you cannot pass an award. No, my lord,
My lord, I must interrupt
Is
now.
nil it.
Submissions are being made contrary to
What is
record.
nil it?
nil it, my lord, is the organization which is in charge of implementing the Aadhaar in those states. That was given to us. We in turn gave it to them.
They have given a final certification. So,
Nil it is still assessing the work.
no, there is nothing, no material on record.
That
to
is
show
the problem, my lord.
Neither the plea, there is neither a plea.
I showed your lordships.
But the appellant appears to be raising disputes on the basis of these clauses of the agreement.
Yes.
For the first time in section 37.
No,
Because
no, no,
even
no. I showed your lordship.
Response.
1 minute. My learned friend is not right.
Notice for
I will
arbitration.
show to your lordships.
Settlement
I will show to your
valid.
lordship the
Will-
statement
will-
of objections.
will
I will show to your lordship the grounds raised in 34.
We'll continue
Yes,
at 3 o'clock or 4 o'clock.
whatever time you. Whatever, whenever your lordship tells me to come.
Today,
Yeah, I'll come.
we'll continue.
But several matters at 2:30. Should we come at 4 o'clock and?
Yeah, I have a matter. Move matter. This is not person.
Then tomorrow we'll continue.
Very.
Tomorrow.
But tomorrow at 2:30, then we can take the court through the pleadings and the particular. At 2:30 tomorrow?
2:30.
Very.
That's
Great.
morning.
Better is it?
When?
Tomorrow 2:30, we can finish.
Tomorrow.
Great.
I'll. The whole thing is down on the radar, but maybe it has been a clean sheet. Is it in the
Court officer, ma'am. Court officer, ma'am. 2:30 ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಇಲ್ಲ ಇದೇ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮೇಡಮ್? Court officer?
Court officer, sir. Court officer, sir.
ಏನ್ ಹೇಳಿ?
Sir, if the matter doesn't reach, will the interim order get extended automatically?
It will, madam. Yeah, you can make a mention at the end of the session, madam.
Okay, okay. Thank you, sir.
R11 ಅವರು SR
ಮೆನ್ಷನ್ ಮಾಡಿದ್ಯಾ? ಹೌದಾ? ಸರಿ. ಹ್ಮ್ ಹ್ಮ್ ಓಕೆ ಓಕೆ ಸರಿ. ಡ್ರಾಫ್ಟ್ ತಗೊಂಡು ಪಬ್ಲಿಷ್ ಮಾಡಿಸ್ಬೇಕು. ಏನಾಯ್ತು ಅದು ನಿಂದು ಮೈಕ್ ಏನೋ ಕೆಲಸ ಮಾಡ್ತಿರ್ಲಿಲ್ಲವಲ್ಲ, ಏನಪ್ಪ? ಅದು ಡೈರೆಕ್ಟ್ ಆಗಿ ಮಾತಾಡೋದು ಒಳ್ಳೇದು, ಕಂಪ್ಯೂಟರ್ ಬಂದು. ಹೌದಾ? ಸರಿ ಸರಿ. ಅದೇ ನಾವು ಕೇಳೋಣ ಅಂತ ಫೋನ್ ಮಾಡಿದ್ವಿ. ಓಕೆ ಸರಿಯಪ್ಪ. ಅಂದ್ರೆ ಊಟ ಆಯ್ತಾ? ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಎಲ್ಲಿ? ಹ್ಞೂ 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 ಸರಿ ಅಂದ್ರೆ ಇಲ್ಲ, ಇದು ಫಸ್ಟ್ ಕೋಟಿ ಕಾಯ್ತಾ ಇದ್ದೀನಿ. ಓಕೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್
Court officer?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ಕೋರ್ಟ್ ಹಾಲ್ ಅಲ್ಲಿ
ಸರ್ ಹೇಳಿ ಸರ್, ಏನ್ ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಬ್ಯಾಚ್ ಅಲ್ಲಿ
14 ಬ್ಯಾಚ್ ಅಲ್ಲಿ ಯಾವುದು ಸರ್?
ನಂದು ರಿಟ್ ಅಪೀಲ್ ಏನಾದ್ರು ಪಾಸ್ ಓವರ್ ಆಗಿದ್ಯಾ 230 ಅಂತ
ನಿಮ್ದು ನಂಬರ್ ಪಾಯಿಂಟ್ ನಂಬರ್ ಹೇಳಿ ಸರ್.
ಸರ್ ಪಾಯಿಂಟ್ ನಂಬರ್ ನನಗೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ರಿಟ್ ಅಪೀಲ್ 948/23.
ಆಯ್ತು ಬಿಡಿ ಸರ್, ಒಂದ್ ನಿಮಿಷ. 948 ಅಲ್ವ ಸರ್?
948
ಲಿಸ್ಟ್ ಇಲ್ವಾ ಸರ್ ನಿಮ್ಮ ಹತ್ರ?
ಪಾಡನೆ
14.14 ಅದು
14.
ಒಂದ್ ನಿಮಿಷ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
14 ಇಸ್ ಪಾಸ್ ಓವರ್. 230ಗೆ ಕಾಲ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಓಕೆ ಸರ್.
ಮ್ಯೂಟ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು, ಮೈಕ್ ಗೊತ್ತಾಗಿಲ್ಲ.
ಇನ್ನು ಕೋರ್ಟ್ ಸಾಹೇಬ್ರು ಬಂದಿಲ್ಲ, ಬಂದ ತಕ್ಷಣ ಮೀಟ್ ಮಾಡ್ತೀವಿ ಸರ್, ಪ್ಲೀಸ್.
ಥ್ಯಾಂಕ್ ಯು ಸೊ ಮಚ್.
ಅವ್ರು ಹೋದ್ರೆ ಹೋಗ್ಲಿ ಬಿಡಿ, ನಮ್ದು ಮಾತ್ರ ಮ್ಯೂಟ್ ಮಾಡಿ. ಇದು ಮ್ಯೂಟ್ ಆಗಿದೆಯಾ ಇದು?
Court officer? Court officer? Court officer? Court officer? Court officer? ಏನ್ರಿ ಎರಡೂವರೆ ಆದ್ರೂ ನೋಡ್ರಿ. Court officer? Court officer? Court officer?
ಒಂದ್ ನಿಮಿಷ. ಗೋವಿಂದ್ ಅವ್ರೆ, ಹಲೋ, ಹೇಳಿ, ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್, ಏನ್ ಬೇಕು ಸರ್ ನಿಮ್ಗೆ?
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 76 ಸರ್.
76 ಏನು ಆಗಿಲ್ಲ ಸರ್, ವೆಯ್ಟ್ ಮಾಡ್ಬೇಕು ಸರ್. ಏನಾಗಿದೆ?
ಆರ್ಡರ್ಸ್ ಯಾವಾಗ ಕರಿತಾರೆ ಸರ್? ಆರ್ಡರ್ಸ್ ಮಾಡಿ ಸರ್. ಆರ್ಡರ್ಸ್ ಮಾಡಿ ಯಾವಾಗ ಕರಿತೀರಿ ಸರ್? 76
ಕರಿತೀವಿ ಸರ್, ಸೀರಿಯಲ್ ವೈಸ್ ಆಗಿ ಕರಿತೀವಿ ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Permission, my lord. List number 2, serial number 9. The other side has completed the contempt, my lord. Kindly pray for the drop the contempt proceedings.
So 9, what is to be done?
List number 2, serial number 9, my lord. I'm for the petitioner, my lord. The other side, the government has completed the
Complied with.
complaint.
Learned advocate Mr. So-and-so, so-and-so. The petition.
Also, they filed the affidavit.
Stated that the order which is subject matter of this contempt proceedings is complied with. Learned advocate Mr. So-and-so.
I'm not appearing in that. I'm not appearing in that case.
Learned additional government advocate, Mr. Pramod Kishan confirms the factum of compliant, paragraph in the aforesaid view. And the contempt petition does not survive. It stands disposed of accordingly.
Much obliged.
Lord, serial number 25, my lord, tree cutting matter, my lord, on 27/9/2024, my lord, 25, serial number 25, tree cutting matter, my lord. This tree cutting, my lord, the PIL, my lord, your lordship on 27/9/2024, your lordship, my lord, directed to redo the, my lord, the process of now in respect of certain number of trees, my lord.
Metro Corporation.
Yes, my lord, K right, Metro.
So what do
My lord, we have, my lord, the TECS, my lord, redone the, my lord, entire process, my lord, and we have filed an application, my lord, along with a fresh, my lord, OM, my lord. AG is appearing in this case, my lord. There is an extreme urgency, my lord. Because of that, there is an extreme urgency because of, my lord, the.
We are for the petitioner, your lordship.
Fourth will take, third will take, third.
Obliged, my lord.
In fact, your lordship are pleased to allow the application in part in this matter, my lords.
If time permits, today we'll take up, otherwise we don't think today time will.
Tomorrow, my lords, can I request for tomorrow, my lords?
Tomorrow, you want?
Yes, an urgency.
Tomorrow also one matter is parted is going on. Take chance tomorrow, no difference.
Lord,
Take chance.
could it be 2:30, my lord? Yes, my lord.
After.
Your lordship, if I may make, we are for the petitioners in this case, there is some inconvenience tomorrow. It may be had day after, your lordship.
We leave it to your lordships, my lords.
All have day after, take chance. Day after.
Day after.
Make
2:30.
one
2:30.
submission. Serial number 8. Interim order may be extended, your lordship. In serial number 25, there is an interim order existing which may be extended.
25. Interim relief to be extended.
Serial number 81, your lordship. Last date of hearing notice was ordered, but not yet served. I may kindly be permitted to serve the copies to the standing councils of medical council as well as the petitioner who represented before the learned single judge. And matter is urgent. It may be taken up day after tomorrow.
What is it about?
81.
What is it about?
It's about the attempts which are, as per the regulations, only 4 attempts were given to the to pass the first year MBBS.
There is a delay of 90 days.
Yes, your lordship.
Will issue notice returnable on.
Already notice is issued. Already notice is issued.
Already issued.
Already it is issued, but not served. It is saying that was dispatched on so and so date. Kindly
Service
permit
awaited.
me to.
Service of notice is awaited. Our, at the request of learned advocate Ms. So-and-so for the Mamta Gurrao Kulkarni, for the appellant, she is permitted to serve copy of the application for condonation of delay as well as that of writ appeal to the counsels who appeared in the writ petition.
Day after tomorrow.
However, this will not dispense with the obligation on part of the appellant to serve the respondents by normal mode of service.
I have already paid the process.
Send over to.
Day after tomorrow.
Yeah. Difficult, but they are.
My lord, may I mention serial number 54, my lord? My learned friend is here. This is a section 37 application, but in that application, my learned friend has also made an IA seeking that they want for stay of award. My lord, there was a direction by a coordinate bench of this honorable court that subject to they pay 50%, then the award is stayed.
That payment has been made.
We have also filed an execution application in Delhi. Now, out of that, they have only paid. The award also contains interest to be paid, but they have only paid 50% of the principal amount awarded. All right, so they have not complied. They were to pay within 4 weeks.
If these
My lord, if this matter can be kept on any, I'm coming up from outside and I don't want to say this. if my lord, this matter can be kept someday as per your lordship's convenience. My lord, this-
Arising out of arbitration act,
Lordship.
arbitration, act, section 9,
No, section 34. Section 37.
37 appeal.
37.
37 appeal is. You can fix it in the week beginning from 9th of December.
I have no objection.
Obliged.
Intermodal may be extended till that date.
9th December.
Please, 9 December, is fine. Intermodal may be extended, my lords. Please.
Whatever order is there, it will extend it.
My lord,
I'm grateful.
You're coming from outside,
I'm coming from Calcutta. Your
Calcutta. All right, we'll try to take up on that.
Lordship, but I still have some, Mr. Appaya is also leading me in this matter, my lord. Obliged.
Passover matters. Bill number 14.9. Mr. Rajendra KR. Correspondent 4 and 5 minutes.
Nobody is there. So none was present in both the calls. Instead of dismissing the appeal for want of prosecution, command the largest interest of this, send over to 12th of December to be listed at 2:30.
This is 14.12.
Appear for the appellant, my lords.
14.12,
Grantee's appeal, my lords, there's a delay of 36 years.
delay of 36 years, dismissed.
So 14.13. Sir, 14.13, Mr. Parshuram L.
48 years delay.
40.
48 years.
So same order, not present on 12th of December.
2:30. So 14.14, Mr. Vishwanath R. Hegde. 14.14.
1 for same order, 12th December.
14.21. 14.21. This is Murthy K. Mr. Murthy K. 14.21.
Same order, 12th December.
So 14.22. Mr. Sudhir VC.
Same order, 12.
14.28. Mr. Nanjareddy PN.
Same order, 12.
14.29. Mr. Karthik C.
14.27. What happened? 10. Okay.
15.29.
29, I appear for respondent number 4, my lord.
Is your opponent, same order. 12th December.
14.30. Mr. Siddhappa BM. Mr. Siddhappa BM. 14.30.
Same order. So in all
14
these, one second, all these method, right? 12th December 2:30 to be listed in board number 2.
14.31.
Same.
Mr. Ramesh Kumar. 14.32. Mr. Sampath A.
Same.
Respondent number 3 and 4 minutes.
12. Petitioner is not there.
14.37. Mr. Bhargav D. Bhatt.
Same. Wealth, 230 will take.
14.43. Mr. Srinivas K.
We have about 26 years.
40 years plus 2 years further in filing the petition.
1980, my lord, is the same. 1980, my lord, is the last sale. Application was filed in 2006.
Sorry, dismissed.
Dismissed. Bill number 82. Mr. D.C. Prabhakar.
Sufficient. 14.6 my lord, not called. Writ appeal number 352/223.
14 point?
14.6.
6.
Yes.
Adjourn.
Writ
13
appeal
December.
352/23 my lord. Yes, estimate.
13 December.
13 December.
It is kept on
13 December.
13 December.
13/12.
This number 82.
Please, my lord. Lord,
My lord,
the
before my
reply-
learned friend starts, my lord, I have a small submission. My lord, I have filed cross objections, my lord, in this appeal. If your lordship is pleased, my lord, your lordship may have it both things, my lord, tomorrow. This case as well as the cross objections.
Let us see what is it about.
my friend seems to have filed a objection, which is actually in the nature of a separate writ appeal. He seems to be impugning the same order. But he seems to have also complied with that order. He seems to be taking advantage of that order and is also now apparently filing a
That's good.
This was earlier heard.
My lord, I had appeared before your lordship. Your lordship was pleased to issue notice. And the matter was kept for his reply because I was seriously aggrieved because a pending inquiry has been stayed. The management's witnesses have been examined, discharged. The delinquent officers in chief, almost 50 pages have been already recorded. Now it's only for his cross-examination and there is a stay on the inquiry, my lord. And I was seriously aggrieved by that and therefore, if my learned friend wishes to press his writ appeal, then in that case, my humble request would be, my lord, let the inquiry proceeding carry on because no prejudice is going to be caused. The law is very clear on that. Assuming I am breaching natural justice, which seems to be his objection in one manner or another, his,
Sir, you are not providing the assistance of legal.
as a matter of fact, his grievance is that initially he wanted an advocate to represent him before the inquiry officer. Subsequently, he wants someone who is not an office bearer of the union to be allowed to represent him. Before that, he had asked for the general secretary of the union to represent him. I had no objection. As a matter of fact, he was appointed the delinquent workman's representative who participated in the proceedings as well. Now, again, he wants a third person who is not an office bearer of the union to represent him. And on that ground, my lord, there's a stay. My humble submission is, my lord, for the moment, for a
But by virtue of this order, inquiry stayed.
Please, my lord.
Where is that?
Kindly have that, my lord. Kindly come to page 34, my lord. That's
Paragraph 9.
I'm sorry.
Paragraph 9.
Paragraph 9. It says, in the facts and circumstances of the matter, the interim order granted by this court is extended until consideration of such application by the labor court and so on. And if I may hand over a copy of the interim order that stays the inquiry. My lord. An argument in demurrer, if I may be permitted to make an argument in demurrer at this stage,
What are the charges?
I'm sorry, my lord.
What are the charges?
The charges your lordship will find at page 66. The fairly serious charges. As a matter of fact, my lord, charge 3 is extremely serious. Charge 3 and then charge 4.
The delinquent is holding what post?
I'm sorry.
The delinquent is holding which post?
He is
He's a
a
journalist.
journalist. He's a journalist.
Journalist.
He is in fact a PhD.
What is your?
And if I may be allowed to make just, sorry.
What is your cross litigation?
Pardon, my lord.
What
My
is the
lord,
cross appeal?
My lord, may I just request you to kindly see page 118, my lord.
$118.
118.
118.
What is it?
My lord, executive members, your lordship got my lord in the middle. My lord, I made a request to permit me to engage the services of Mr. M.J. Pandey, my lord, who is a member of the executive committee, my lord, Western region. My lord, they disallowed that. My lord, now your lordship, on the ground that, my lord, he is not an office bearer. On the ground that, my lord, M.J. Pandey is not an office bearer. My lord, definition of office bearer, my lord, has been mentioned in Trade Unions Act, section 2B.
What is your cross petition?
Pardon, my lord. My
What-
cross petition, my lord, is that this writ petition was disposed of on their submission, my lord. They said, my lord, it is not an industrial dispute and remedies under section 13B. My lord, having regard made on the basis of that submission, my lord, learned single judge disposed of the writ petition, relegating, my lord, me to go to the labor court under 13B. My case is that, my lord, this is a dispute under 2K. My lord, standing orders clearly allow assistance, my lord, by an office bearer of the union. My lord, not permitting, my lord, is violation of the service conditions.
2K industrial dispute.
Industrial dispute. My lord, that, my lord, was not considered. My specific case is that, my lord, this is a 2K dispute. And, my lord, this has been exposed by the trade union. My lord, it is on question of prestige, my lord, for them, not to allow Mr. Pandey. My lord, the Trade Union Act and the definition of office bearer, my lord, is very clear. This was put, my lord, to the other side. Then, my lord, the submission was that, my lord, this must be a clarification, my lord, under the section 13 of the Standing Orders Act. My lord, learned single judge suggested, my lord, you allow him to engage M.J. Pandey. He is an office bearer.
Or learned advocate, learned senior advocate, Mr. So-and-so, for the appellant.
My lord, may I just bring one provision? My lord, if I leave it to lordship.
Yes.
My lord, section 2B of the Trade Unions Act clearly states, my lord, that office bearer in the case of a trade union includes any member of the executive thereof, but does not include an auditor. Admittedly, my lord, 118, M.J. Pandey is a member and office bearer. Office member also is an office bearer, my lord, as per the statute.
That's a slightly fallacious argument, which if your lordship wishes, I can dispel in a moment.
And, my lord, it is on the basis of their submission, my lord, writ petition was disposed of, not on my submissions. It is not open to them, my lord, to retract from that position and file this writ appeal. My lord, having made a submission and that submission being accepted, this writ appeal, my lord, my respectful submission is not maintainable.
You are for number 4 or?
I am for number 1, my lord, union.
Union.
Yes, my lord.
Or learned senior advocate, your senior advocate?
No, my lord.
Mr. So-and-so, so-and-so, for the appellant. And learned advocate, Mr. So-and-so, so-and-so, for number 1 original petition. Appellant Trust of India Limited has filed this appeal. Calling in question judgment in order dated 18th September 2024 of learned single judge, whereby the writ petition filed by the respondent number 1 union came to be disposed of with certain observations and directions. The dispute revolved around, as addressed by learned single judge, was with regard to the providing assistance of a legal representative of a representative to the delinquent. One Mr. Indukan Dikshit, who was a journalist working under the appellant. The delinquent had been facing certain charges and was subjected to inquiry in that regard. The charge sheet figures at the charge sheet dated November 6/11/23 into bracket page 66 and it's B bracket over. Enumerates the charges which include that despite the delinquent having been transferred from Ranchi to Bengaluru, did not report for duty at the transferred place. The second charge relates to making false statements in respect of absence, in respect of his absence from work. The third charge was about intimidating the wife of Chief Executive Officer by calling her repeatedly on her mobile phone until, out of dismay, the wife of the executive officer blocked the number. The fourth charge was about the fourth charge alleged that the delinquent indulged into intimidation and overweighing OVER AWEING line managers. And despite advised, did not improve his conduct. During the course of the inquiry, paragraph, the delinquent made a request to permit him to engage services of an office board bearer of the trade union. The request was refused. Another representation was made by the delinquent on the same line, which was also not acceded to.
I'm sorry, my lord, there's a correction. It was acceded to. The
Was
general
acceded.
secretary, yes, the general secretary of the union.
My lord, he retired, my lord. He retired.
So then what prompted him to go to the learned single judge?
My,
The difficulty is he first asked for a named person. And before a decision could be taken on that, he moved the authority letter of the general secretary of the union. He was permitted. Your lordship finds that at page 257. Then again, he came up with another person. Now that other person, my respectful submission, is not an office bearer, despite what my learned friend just read to my lord in terms of section 2B and so on. Your lordship may have page 257.
However, the delinquent wanted another person to be appointed as his representative. Since that was not acceded to, the union filed a petition seeking
conciliation.
prayer that the delinquent, as responded before, should be permitted to engage the services of an office bearer. Paragraph. The dispute addressed by learned single judge was whether the contentions raised by before learned single judge, whether the dispute about engagement of services of office bearer of the trade union as asked for by the delinquent would fall within the purview of the definition of industrial dispute within the meaning of section 2 into bracket K of the Industrial Disputes Act 1947 or not. Full stop. Learned single judge took view that this issue has to be addressed and decided by the labor court concerned, in view that the respondent number 3, appellant, does not have its own standing order. And it is governed under the Industrial Employment Standing Order 1956 and the general rules thereunder. Paragraph, learned advocate for the respondent attempted to submit on merits that the person suggested by the delinquent is also a office bearer of the
Yes.
union. Full stop. This contention is hardly relevant in this controversy. When, learned judge has required the petitioner to approach the labor court concerned to decide the aforesaid aspect. Full stop. The bone of contention is that while making such observations and directions, learned single judge has continued the interim order whereby the inquiry is stayed. Please. Pending the inquiry is stayed, full stop. In other, full stop, learned advocate, learned senior for the appellant would submit that while it may be open for the petitioner to approach the labor court as permitted by learned single judge, in the meantime, inquiry proceedings need not be arrested. Full stop. The court sees justification in this submission. Full stop. The attempt to repeatedly ask for the office bearers as representative in the inquiry proceedings, and the dispute in that regard would prima facie smack the intention on part of the delinquent to prolong inquiry. In the circumstances, this appeal is in the circumstances, it would be appropriate that the inquiry is not stayed, even as the parallel proceedings before the labor court may be initiated or may continue. Paragraph. Appeal is admitted. It shall be listed for final hearing in the week beginning from on 8th of April. Full stop.
8th of February, Your Lordship. May I ask for a moment, Lord, because I have to travel here, only for a second. 8th of February is a Saturday, my Lord.
No. Oh, I see. Yes.
8th of February is a Saturday, my Lord. So
It's the 24th March,
24th of March.
or tell your date in March or April.
Very well, my Lord, if Your Lordship can give a fixed date, say the 26th is a Wednesday, my Lord, if only if it suits the court.
26th May,
26th of March, Your Lordship said.
6th of March. By of interim relief, it is directed that the inquiry against the respondent number 4 delinquent shall go on. However, any action is to be implemented, which shall not, any action shall not be implemented against him without the permission of the court,
Permission of this court, my Lord, or the Labor Court?
this court.
My lord, in the meantime, my lord,
If the labor court says, the labor court concludes in the favor of the delinquent, then we have to appropriately modify final order at that time.
Quite right, my Lord. My only humble
Permitting the inquiry to go on, that's.
Absolutely. My Lord, I
Lord,
appreciate what has fallen from my Lord, but because Your Lordship made a reference to the proceedings in the Labor Court, I may tell my Lord, that is an exercise in futility, because Your Lordship may in fact record my statement here and now that if the Labor Court is tasked with only determining under Section 13A of the Industrial Employment Standing Orders Act as to whether or not he is entitled to be represented by an office bearer, my statement is he is. So there is really, it's an exercise in futility before the labor court.
Therefore, we are not commenting anything.
Quite right, quite right, quite
My
right.
lord,
quite right.
let the proceedings before the labor court may continue, my lord. Your lordship may make an observation.
You said so.
We have not stayed.
Not state.
On the contrary, we have said it may simultaneously. continue.
Yes.
My lord, otherwise, my lord, now in the event, my lord, inquiry is concluded. And my lord, the entire things are stalled.
Dependency of this appeal shall not be a ground for any of the parties not to proceed before the labor court.
No, very good. God bless.
Number 108, Mr. C. Shankar Reddy. Mr. C. Shankar Reddy, 108.
Nobody is there. 18th December. You are there? Why it is at 2:30, 108?
Objections.
You're filing something?
Objections to the affidavit
Yes, madam.
filed by the.
It is decided or not represented?
Private,
See,
unaided college.
1 week time. 1 week time. Because one more,
They have asked for the revised pay,
one more inquiry report is there.
the complainant, my lord, that is the Trianon College.
So decided.
Yes, my lord. Over here,
I may be permitted 1 week time because one more inspection
No,
report
no,
is
no.
there. Wherein, Your Honor, the institution has.
question is, my lord, if I may just, My
institution
lord,
has
if I-
clearly admitted before the authorities that. they
If
are
I may
going to
just take
implement
2
the
minutes,
state
my
pay
lord.
scales. State pay scales.
the impugned order is at 147, which directs 2 and 3 to consider the representation. Now, 2 and 3, my lord, is the Department of Higher Education and Technical Education with regard to revised 6th pay scale. Now, this being a private unaided college, it is for the college that is the management that needs to look into the payment of the 6th pay to the employees concerned. So the government accordingly, in my affidavit dated 24/7, we have issued a letter to the institution. My affidavit, my lord, is dated 24/7/2024, wherein we have stated para 10 of my affidavit, my lord. It's a private educational institution.
is entirely contradiction to the order passed by R1. The observation made by the respondent, page number 4, that is the affidavit, paragraph number 10, is entirely contradictory statement to the order passed by R1.
Order passed by?
Passed by R1, Principal Secretary. Entirely contradictory statement. So, my lord, I want to produce one more inspection report where the institution itself has declared before the authorities they are bound by these state pay scales. But these respondent 2 and 3 are saying that they are not bound by that state government pay scales.
Now, the
Not
representations were made by to whom? Your representations are addressed to whom?
For the complainant, Your Honor, for the institution, for the union.
Addressed to whom?
Please, madam.
Representations were addressed to whom?
Address to R1, 2 and 3 for 3U.
This representation dated 29/11/22 was addressed to whom?
To all 3U.
All three means who are the
Principal
authorities?
Secretary, Commissioner, and Direct. And Direct.
My lord, the representations are at H and J, wherein it's addressed to the commissioner and director, not the management. This is a private institution, is my humble submission. So the appointing authority needs to look into the arrears and the salary fixation. As per the Karnataka Education Act, my lord. Karnataka private.
Want to use one more document. So it is very clear that the institution, they themselves declaring before the authorities, they are bound by the state government pay scales. And they have declared that they have extended. The inspection report clearly says that they have not extended. These are all the contradictions. And in spite of the same, the respondent number 1 has passed an order under section 131 that the institution is bound to pay the 6 pay scale, state pay scale. Not the pay scale, Your Honor, it is the state pay scale. Page number 39, Your Honor.
You are what, teacher?
No, non-teaching staff. We are non-teaching staff. Non-teaching staff.
The petitioner was a member of non-teaching staff under the Dayananda Sagar College of Engineering, Bengaluru. In the writ petition number 11509 of 23, his grievance was with regard to non-extension of the revised 6th pay commission pay scales in terms of government order dated 19/4/2018. Full stop. Seeking such benefit, the petitioner had made representations dated 29/11/22 and others before the respondent authority.
One submission.
The respondents are the state of Karnataka, the Department of Higher Education, of Technical Education. Paragraph. On a single judge, without expressing any opinion merits, directed respond 2 and 3 to consider the representation of the petitioner within stipulated time. In respect of alleged non-compliance of the above direction of non-consideration of representation, that the present contempt petition is filed. Also, in response to the notice, respondents have filed reply in which it is stated inter-alia that
Para 10.
Para?
Para 10. Para 9 and 10.
While several representations came to be made by the petitioner to the principal of the Dayananda Sagar College of Engineering, the said engineering college is not an aided institution. But it is a private unaided. It stated that the government ordered it is 1918 will not apply to the employees of the will apply only to the aided institutions. Therefore, the petitioner would not be entitled to benefit under the said government order. And it is further stated that the scale of pay to be extended has to be in consonance with Rule 5 of the Karnataka Private Educational Institutions Integrated Discipline and Control Rules, 1978.
In the next page, my lord, we have said that the government does not carry authority over administrative work.
Annexure 2, Your Honor.
It is,
They themselves directed the
it
institution
is further
to
stated in
produce salary
Chapter 10
slips, Your Honor.
that the
That they have not
Private
produced.
College of Engineering is a private education institution. That the state government does not carry any authority for the administrative work of the private institution, and the extension of sixth pay scale benefits to the employees is policy decision of the governing council oblique management of such private institutions. Paragraph. It is the stated paragraph. It is the stated in the affidavit extracting from paragraph 10. As such relief does not like.
Governing council headed by the principal, Your Honor. Principal has not answered, Your Honor.
Up to current pay slip of the petitioners. Full stop. It is submitted on the basis of the above fact situation that the contempt against the respondent 2 and 3 would not lie. The same may be tapped. Full stop. There is a great substance in what is stated by of defense by the respondents. It could not be said that any of the respondents 2 or 3 have committed any contempt, much less willful contempt. The contempt proceedings are dismissed.
Number 109.
Message to the complainant.
Lord, in identical matters,
Lord, this is
writ
not
appeal was
facts of the
filed
case
and
is totally
the
different, my
matter,
lord.
Lord, is in Supreme Court. I produced the order.
Make the stay, my lord, is misleading the court, my lord. Kindly take the
In the-
impute judgment in page number 38, annexure D, my lord. Para file, lord, and single judge clearly observed that, my lord, this case is totally different, my lord. Para 5 may permit to read, my lord. There is observation by the learned single judge, my lord. The case is totally different than what my learned friend is saying.
There are a batch of matters, my lord, which were disposed of. The peculiar circumstance here is, my lord, the school was opened on a particular date, and whether the proportionate service weightage is to be given is the issue involved. Now, the writ petition was allowed, writ appeal also was allowed.
I'm not seeking
And-
proportionate weightage in this case, my
Let
lord.
me, my
This
lord,
case,
complete,
my
I am-
lord, the September 1st, 2007 school is opened, my lord. Before that petitioner can't be
I co-
joined as a teacher, my lord.
She can't interrupt, my lord. I'm not arguing against her. I'm only submitting what facts are. In September, my lord, the school opened, and proportionate weightage is to be given or not. In the circumstances where September is the school opening is the issue involved. So the learned single judge said, because the school itself opened in September, the proportionate weightage has to be given. I'm stating, Lord,
Not
what
proportionate weightage, my lord. This is
I'm
complete
support.
clear.
Anyways,
Yes,
Lord,
my
he
lord.
can.
Please, my lord.
This order of learner single in your favor or?
It is in her favor, Lord. And thereafter, the writ appeal also was filed, and it was this single judge's order, Lord.
After this, no.
Anyway, she let him argue.
There's no writ appeal is pending for this order, my lord. This order is not at all challenged by my learned friend.
Tell us facts. What are the facts?
My lord, 2011, my lord, April 26, 2011, recruitment notification has been issued, my lord. In that 2011, my lord, weightage has not been granted. Hence, my lord, several petitioners has been challenged that order. Then this honorable court has been allowed the petition and weightage has been granted, my lord. That they went to writ appeal and up to apex court, my lord. Then after that, weightage has been given, my lord. In 2015, there's an endorsement issued to the some other petitioners, my lord, that proportionate weightage means they have not appointed in the June or July. They have appointed in August, September, November, like that, my lord. Hence, will not grant the proportionate weightage. That has been challenged by this honorable court, my lord, in 2015. Then 2020, they have that has been allowed, my lord. That order has been challenged by my lord in 2020. And 2023, my lord, 2023, 19th July 2023, my lord, that order has been dismissed. Hence, my lord, they have challenged that writ appeal before the Supreme Court and obtained the stay, my lord. But in this case, my lord, particularly this case, my lord, petitioner appointed in September 1st, 2007, which is school open day, my lord. School itself is established as per the government order and petitioner has been appointed, my lord. Hence, petitioner is seeking for the students is a complete academical year. For teachers who have appointed when school open day is be considered as a complete academical year. Hence, grant me 5% of the weightage, my lord. Hence, learner singles observe that in para 5, my lord, there is no mistake by the petitioner appointing on the same day. Hence, issue grant 5% of weightage and issue the appointment order to the petitioner. Since he is a age bar, now he is a 45 years age, my lord, and is still working in the same institution as a social science teacher, my lord. He is a temporary employee, my lord. Since from several years, he is working as a temporary employee, madam. My lord, it's 2011 recruitment is still pending, my lord. Hence, my lord, contempt proceedings may be initiated and direct them to appoint a petitioner as a permanent teacher, my lord. And para 40, my lord, page number 40, para 5, it's observation, my lord.
And if your lordships will permit, she will not permit me to. Okay. Now, my lord, I filed a memo.
Why you are not complying?
No, that's what. On 29/2024, I filed a memo. The identical matters, my lord, if not this writ appeal, the identical matters relating to service weightage, based on which this order is also passed. This order is passed based on the writ appeal orders, my lord, which were disposed of, are all impugned before the Honorable Supreme Court. And therefore, my lord, Honorable Supreme Court is seized of the matter where the service weightage issue itself is pending. Now, granting in one case, my lord, I understand.
Show us the memo of SLP and the order.
Yes, may I, my lord, show to your lordships the 20th September 2024 memo, my lord, which I have placed.
Right, okay.
Yes. SLP order, my lord, is of
Last time you showed.
in 24767 of
You're not
23.
able to know anything from this order of. What is
No,
the-
this says, my lord, that SLP number so-and-so, respondent in so-and-so, so-and-so. It says until further orders, further proceedings in contempt case being so-and-so, so-and-so are stated. These are identical matters where, my lord, the same case is involved. The service weightage issue itself is involved.
This is the
I am saying, my lord, it will.
judgment, my lord, which has been challenged in this before Supreme Court, my lord. Both case of the facts are different, my lord. Here nowhere mentioned that.
Let her give a copy, I'll go
As-
through it.
This writ appeal judgment, my lord, 360 of 2020 is clearly observed by this honorable court.
Anyway, leave it. She doesn't want to. Anyway, my lord, I leave it.
This order
Because
has been
let her
challenged.
share
by-
it with me, I'll persuade, if at all, my lord. You go through it. Yes.
For this only they are showing the writ appeal before this honorable Supreme Court, apex court, this is order has been challenged.
This order.
This order has been challenged.
Challenged and there is a stay operating. I am saying, my lord, because it is based on the writ appeal order, this judgment, my lord, of which the contempt is alleged. That is
For
stayed by the
this
Supreme
writ
Court.
appeal order has been challenged for that, and this writ petition has been, I have filed a contempt petition, both are not same, my lord. Facts of the case is totally different, my lord. Kindly take page number 40 of the contempt petition, my lord. Impugned order passed by this honorable court's learner single judge in para 5, there is observation, my lord. And when this order has been passed, here the respondent also, my lord, learned friend participated and directed to issue the appointment order. Since in the 2011, this appointment is pending and petitioner is age barred now. And the respondent institution taking the petitioner service till today, my lord. Examination, my lord, petitioner has been participated and scored 52.29%, my lord. And weightage has been, how to be given 4 years as a 20%, my lord. They have given 15%. That is, my lord, it comes to 67.55%. Cut-off percentage itself is a 65.55%, my lord. Only 0.26% is shortage, my lord. If they give 5% of the weightage, it comes to 72%, my lord, more than the cut-off percentage.
No, I don't know, my lord, what order is, I have just collected the petition. Lordships may have it some other day, my lord, I'll seek instructions. 9th December. Grateful.
This is number 110. Mr. K. Prasanna Shetty.
My lords, I was directed to take instructions in this matter, my lords. Now, regarding the consequential benefits, my lords, the finance department has approved and the commissioner office has been directed to release the funds. Lordship, it may 3 weeks, within 3, and we have also sent it to the treasury. Within 3 weeks, it will be released, man.
On 20th, 11, 24, the court had no occasion to pass the whole. Sorry. Today, when the petition comes up for consideration, learned government, some organization produces communication dated 25/11/24, state that the payment of the
25.67 lakhs.
if it's under consideration and the same shall be processed and paid within
3 weeks, my lords.
full stop. It is provided that the consequences benefits may be paid to the petitioner within 6 weeks.
Lords, may I kindly note this
The
letter.
copy of the aforesaid communication dated 25. Taken on record. The contempt proceedings does not survive, they are closed.
Please.
111. Venkatachalapati.
Instructions are the compliance has been complied with, my lords. I'll place the compliance on record, my lords.
Yes.
The order has been complied with, my lord. I'll place it on record, my lords.
Have to file the compliance report.
State government has filed the compliance minutes.
Learned advocate, Mr. Swansea states that the author of learned which was regarding taking action against the private respondents. Consequent to the notice issued under section 313 of the PBMP Act. Post, the statement, the
Weeks accommodation.
contempt petition disposed of as not surviving, the compliance affidavit shall be filed. Notwithstanding the disposal of the present petition upon a statement as aforesaid, if filed within 1 week.
Please.
Within 1 week, full stop. Liberty is reserved to the respondent in case of genuine difficulty.
Great.
Revive the petition. File the compliance affidavit.
Please.
The matter shall be listed on 9th of December to ensure that the compliance affidavit.
Please. Okay.
It is disposed of as such.
Great.
Yes.
This is number 112.
I appeal for the complainant. My lord, on the previous state of occasion, the learned government advocate has pointed out in page number 17 of that compliance affidavit that a government order has been passed. I may be permitted to challenge this government order in a writ appeal, and the present contempt petition may be disposed of accordingly, my lord.
Learned advocate Ms. So appearing for video conferencing, invited it, fairly stated that the decision is rendered in that view. And in that view, the directions of learned single judge is complied with. However, she requested the court to permit the petitioner to institute challenge to the said order of endorsement on merits. First of such liberty is reserved without expressing any opinion on merits. Present contempt petition is disposed of accordingly. Next.
So number 113. To Vasant Kumar.
And for the complaint note.
Pardon?
But the last case, they are issued the only allotment letter. There is a direction to execute the necessary documents in respect of site number 2085. Still, they have not executed any deed. Then only the allotment letter has been issued. Kindly para 37, page 37, my lord. Upper to portion into order may kindly be seen, my lord. The first prayer. The BDS directed to allot the site number 2085.
Site is allotted to you.
Yes, my lord, it's allotted, but no sale has been executed, my lord. You have to execute.
What is not executed? Held it. Leased it.
Lord, they are supposed to, as per the letter of allotment, Lord, they are supposed to comply with certain
return of the documents
On
issued.
20th/11/24, the court had an occasion to pass the following order. Then quote this order. The order was passed after quoting. Since the learned advocate for the petitioner, Mr. So and so was not present on that day. Paragraph. Today, learned advocate of the petitioner appeared to video conferencing to submit that though the site is allotted to the complainant, the documents are not executed. Paragraph. In this regard, learned advocate for the respondent stated that if the formalities are completed by the petitioner, the necessary actions will be taken. Therefore, while closing this contempt petition as not surviving, it is observed that the parties shall comply with the formalities about the execution of the document pursuant to the allotment of site within 10 weeks from today. Please.
Much obliged.
Serial number 114. Mr. Deepak BR.
Now, replies filed.
No, my lord, he was directed to file additional plea.
I've already filed it, my lords. I've already served a copy also.
So I received the copy, sir.
It's already filed on 23rd itself. And
You are
Advocate
not-
General's office has already received.
You are not supposed to file it.
My lord,
You are not supposed to file reply.
my lord, I had pointed out to my lord, how bare the pleadings were. And my lord was pleased to direct my learned friend to file additional pleadings.
Bane land.
Yes, my lord, the formation of a technical committee headed by the Deputy Commissioner Revenue.
Now you file your formal.
Yes, I will do.
Reply shall be filed by the respondent within 4 weeks.
Obliged.
Interim order may be extended.
Put upon 10th January.
Obliged.
Much obliged.
Interim order granted, arrears will continue to apply till the next day.
Serial number 115. Mr. Gautam AR.
Infectious.
This petition challenges certain proceedings initiated by Karnataka Lokayukta on the ground, number one, it is outside the purview of Lokayukta Act, and second one, it infringes on the judicial review power of this honorable court under Article 26. Now, the Bruhat Bengaluru Nagarapalika initiated certain proceedings against the developer on the ground that he encroached Rajakalwe and all that. That is on merit. Now, a writ petition was filed before this honorable court, certain directions are issued. Then on a Sunday, they approached the Karnataka Lokayukta, and it's almost like a writ petition. And the Lokayukta passes an order which my respectful submission would be similar to the judicial review power that can be exercised by this honorable court. Section 8 of the, I may draw your lordship's attention to the complaint at Annexure A, page 18. But this is a public interest litigation only to see that, my lord, the authorities do not exercise the power which is akin to judicial review power of this honorable court. Section 8.
Currently, my lords, if I may submit, these issues remain academic now. Because writs were filed by us, the complainant, the others, there are orders passed in writ petitions against directing BBMP to conduct a survey and carry out the necessary work. So now it's only academic, my lords. Because we approached, because there was the apprehension that they'll demolish my wall, I approached the Lokayukta, that's all.
Then the proceedings before Lokayukta become infructuous. The Lokayukta should make such submission. My only apprehension was it was in the nature of a writ petition.
You are for Lokayukta.
You have interim orders granted by this on court. We are just saying await orders.
In the meanwhile, writs, orders are passed in the writ petitions. Directing, my lords, the survey, there is allegations where, my lords,
Place those all on record.
my lords, I think BBMP has already placed a memo.
They've
It's
chosen
already
the right
placed
path.
on.
Chosen the right path. Therefore, the proceedings before the Lokayukta become infructuous. They have served a copy on me. I think this is the writ petition. 18546.
Yes.
2095.
185.
May pass on there.
It's, I think, filed with a memo by the BBMP.
Please, my lord.
At least
I
they have
filed it
served
along
on
with the
us.
memo, my lord. I have 2 copies, my lord.
For ready reference,
Court of sir. Told that they've served it on us.
One 18546? No.
Yes, my lord. 18546. Please, my lords. That's the 4th respondent against who had approached the Lokayukta because of the urgency, and it's not on Sunday, it's on Monday, subject to correction.
Not, order says though it was Sunday by making special mention. But I am not on that, but
Our apprehension was that, my lord, because of orders passed for others, they were trying to demolish my wall, so I had gone there complaining about it. Ultimately, we also approached the High Court, and there is a direction issued that in our presence, survey should be conducted, inspected, necessary action to be taken. That's exactly what the Honorable Lokayukta also wanted to be done.
One five, 546 is, what is the order there?
Let's, 18546 is the order dated 16/9/22, my lords.
What is the direction?
Lord's direction is, my lords, at para 4, your lordship should get. BBMP's counsel's submission that survey has been conducted. Copy of survey report will be furnished to petitioner, and after affording an opportunity to reply to the said report, appropriate action will be taken if it is found that petitioner has put up construction on the Raja Kalve. And we had approached the Honorable Lokayukta only because the neighbor had got such a direction, my lords, and they were trying to demolish without notice to us. So that's the only thing. The Honorable Lokayukta had only summoned the officials for records. That has been challenged. So I would only have submit, so far as merits, my lords, it's not concerned. Only academic issue whether Lokayukta could have
now
gone
the
into these
proceedings
issues.
have become infructuous.
Whether it could.
The present was a petition filed. The public interest petition, in which the prayer was to set aside the proceeding initiated by Respondent 1 Law 5. Contempt complaint dated 10/9/2020 filed by Respondent 4. The main prayer is from the petitioner can raise various contents in the petition. It appears that during the pendency of the present petition, development took place. Petition number 18546 of 2022. We filed before this court in relation to the very subject matter.
Please.
The same was disposed of by a single judge of this court on 16th September 2022. The order dated 16th September 22 was produced by learned counsel of parties for Procedural report. In view of the above order, in view of the above development and the order of the High Court, the subject matter and the prayer of this public interest petition has become academic. Full stop. When this was submitted by learned senior advocate Mr. Panindra, learned advocate so and so petitioner was entirely at his receiving end. Paragraph. In that view, since the subject matter and the issue has become academic, the court is not inclined to go into it and is not further inclined to continue, not inclined to keep the public interest, keep the present petition pending. It is accordingly disposed of without going into the merits.
Please.
Expressing anything about the matter.
Please.
Seal number 116, it is Som Sundar Rao.
I appear for appellant lordship that there is a 49 days delay in filing appeal. 49 days.
What is it?
That this is a 49 days delay in filing.
Delay will consider, what is the
Let
subject?
the goes issue notice and come other side. I argue the matter.
Hmm?
On merit, I'll argue the matter later on.
No, no, argue right now. You are challenging the penalty after how many years? Three decades.
No, there is no 3 decades. Lordship may kindly, there is one
Five.
more.
25 years. Not 3 decades,
Yes.
25. That is the point.
And learned single judge did not consider on merit. There is only latches of delay. Therefore, I challenge that this that order. Soon after he retired from service, who is a traffic controller in KSRTC, the punishment order was issued by the disciplinary authority.
What was the award of the tribunal? Against that,
Lordship,
what was the award of the tribunal?
I relied on learned single judge order.
What was the award of the tribunal?
The award of the labor court in favor of the workmen. Then they have filed, management has filed a writ petition.
Or what was the award? Where is the award?
That Lordship may kindly say. Labor court award.
Page 60. Yes. Not page. Page 60, 68.
Page 68.
One 6. While the present, the writ appeal, this appeal at the instance of Karnataka State Road Transport Corporation. No, this appeal at the instance of original discipline 2. Workman. Is directed against judgment and order dated 1st February 2024, passed by learned single judge, whereby the petition filed by Karnataka State Road Transport Corporation came to be allowed, setting aside the judgment and award of the Industrial Tribunal Bangalore in Industrial Dispute number 100 of 2011. While the appeal is delayed by 49 days and accompanies the interim application praying for condonation with delay, regard and available record the copy of the impugned order of law in a single judge. In that light paragraph, the court could examine the very merits of the impugned judgment and order. Full stop. The challenge before law in a single judge was to judgment and award of the industry tribunal, whereby the tribunal had held that the workman was justified in raising the industrial dispute after lapse of 24 years. It further interfered with the penalty imposed on the workman by the management, which was management, full stop, which was reduction of basic pay by withholding annual increment for a period of 1 year without cumulative effect. Full stop. The said punishment order dated 11/31/10/86 was set aside came to be set aside by the tribunal. Full stop. After the said order was passed in 1986, the workman invoked the jurisdiction of the tribunal in the year 2011, which was after 26 years. 26 years. Full stop. Learn a single judge has noticed the above aspect along with the other aspect. Full stop. Following was the observations and findings recorded by learned single judge in paragraph 8 of the order. So page 26, paragraph 8, quote for full stop. The judgment and order of learned single judge setting aside the order of the tribunal and allowing the appeal could be said to be eminently just, proper, and legal. No error could be booked. From this court is entirely in agreement with the order of learned single judge when the reference was invoked after 26. Reference was made after 26 years. Yet the tribunal proceeded to grant the relief, overlooking the inordinate delay, which itself was to be fatal for the workman to get any relief. Appeal is dismissed.
Serial number 19, my lord, we have complied the order. Or it does not survive for consideration. Serial number 19, my lord.
Contempt
19, my lord.
matters. Contempt matters, there are certain compliances done, my lord.
19, my lord.
Yes, it is complied with.
May be disposed of.
You are
Maybe. I am for the accused respondent.
I'm for the complainant.
Complainant is.
We have some submissions to make on
Lord,
this.
there's
We posted a different date, my lords.
Lord, there's no, my lord.
Please, my lords.
9th December at 2:30.
I'm sorry, my lords.
9th December at.
Please, my lords, I'm grateful.
My lord, serial number 24, my lord. My lords, on the last date, which is on 12th of November, my lords had directed them to produce, my lord, these are daily wage laborers. Before the single judge, they had given a submission that they will appoint them, my lord. No reinstatement order has still been produced, my lords. Date, my lord.
Date in January 10.
My lord, serial
2:30
number
PM, my lords,
92, my lords. Plus serial-
63, my lord. Serial number 63, my lord. Compliance has been done.
Serial number 103, my lord. It's been 4 years since I've seen my child, despite having an order in my favor. Any short date may kindly be given. Subject matter, it's a family dispute, my lord. I'm appearing for the mother. The custody is with the father as per the joint agreement between the
Chance on 13th December.
Serial number
parties. It's a
85, my
short
lord.
date. It's been 4 years since I've seen.
Here then it is not possible. 13th December. Yes.
Serial number 85, my lord.
Serial number 63, my lord. Compliance has been done. Compliance is done. Order is complied, my lord.
For the complainant. Both the advocates for learned, both the advocates.
My lord, this is serial number 73.
As well as learned advocate for the respondent jointly stated that so and so. Namely. So jointly stated that the order, which is subject matter of this contempt proceedings, is complied with in view of the statement. Nothing survives in the proceedings. Petition is disposed of as not survival.
My
Your lordships, serial number 71, your lordship. This option,
Not went to one. to
serial number 85, my lord.
Yes.
your lordships,
My
serial
lo-
number 71. I've complied with all the office objections, your lordship.
It will be posted.
My lord, in,
Serial number 85, my lord. Serial number 85, my lord. Regarding the payment of compensation, complaints is not made. 2 times the matter has been adjourned, my lord. Kindly short it, please, my lord. Because the lands have been acquired more than 15 years back, my lord.
My lord,
Serial number 99, my lord, 99.
All entry model will be.
Meeting.
Also, my lord, how much submission, my lord?
Serial 93, my lord.
They are not served the copy and we, serial number 22.
We'll go to them and we'll go to them and bring copy for you. Yes.
My lord,
Serial
Serial
number
number 99, my lord, 99 and 99.1 must be delinked because the writ appeal, 4th time the office objections has not been complied with. But the contempt petition, which is the 99.1, has everything has been complied with and the matter is not moving forward. It's a matter of education where college got a autonomous status and the RGUHS has not complied with the UGC's guidelines.
You're afraid of rights.
My lord?
My lord, 104.
My lord, serial number 92, my lords, I mentioned for interim order extension. Also, my lords, it's come under the caption for PF payment, my lords. The parties are government. I've served them and filed acknowledgement, my lords. It's still come under the same caption of PF payments, my lords. It may be listed under the regular head for hearing.
My lord, 104 pertains to demolition.
What do you want?
My lords, it may be listed under the regular head of writ appeals, my lords. It was heard for interim order. Now it has to be considered on the merits, my lords.
10th January. Yes, Mr. With,
My lord, 104, my lord,
Serial number 99,
104.
short date must be given, my lord, please.
My lord, 104.
Serial number
104, my lord.
93, my lord.
Madam, serial number 85, madam. Madam, serial number 85 ಎಷ್ಟಾಕರು ಸಾಹೇಬ್ರು? Madam. Madam, serial number 85. Serial number 85. 85.
85, 17-2, 17-2.
78. 94. Serial number 78. Madam, serial number 17-2 next year.
Court officer, serial number 47, next date.
Next year. Sir, serial number 85 next year.
ಹೇಳಿದ್ರಲ್ಲ ಸರ್ ನೀವೇ ಕೇಳಿದ್ರಲ್ಲ ಸರ್ ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಹೋಗುತ್ತೆ ಎಂಟ್ರಿ ಮಾಡ್ರು ಎಲ್ಲೆಲ್ಲಿ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಇದೆ ಎಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಇದೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಬೈ ನೆಕ್ಸ್ಟ್ ಡೇಟ್
Serial number 47, next date. Court officer.
85.
94
17th, 7th next December.
ಮೇಡಮ್ 94 ಬಂದೆ ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್ 78
ಅಲ್ಲ ಅಷ್ಟೊಂದು ಲಾಂಗ್ ಡೇಟು ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಸೋದಾ? Can we advance?
Court officer.
ಈಗ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ ಅದೆಲ್ಲ
78, IF stay pending ಇದೆ sir.
If you not start the date, they will be.
Serial number 78, IF stay pending ಇದೆ sir. 78.
Why this?
ಅವ್ರು appear ಆಗಿದ್ದಾರೆ.
serial number 8.
For court officer, serial number 76 ಏನಾಯ್ತು? Date? Serial number 76, sir.
Stay pending ಇದೆ number. Serial number application
Sir,
Court officer? Court officer?
sir,
Hello?
serial number 8.
ಎಲ್ಲದಕ್ಕೂ
Madam,
ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್ ವೆಯ್ಟ್ ಮಾಡಿ ಸರ್
76 date
ಆಮೇಲೆ
ಏನಿದೆ?
ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ
Madam,
Chart
December.
date, sir.
ಮಾಡ್ತೀವಿ ಎಲ್ಲ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ವೆಯ್ಟ್ ಮಾಡಿ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಇದ್ರಲ್ಲಿ ಹೈಕೋರ್ಟ್
serial number 85 ಮೇಡಮ್ ನಮ್ದು.
ಅದು ಅವೇಟ್ ನೋಟಿಸ್ ಅಂತ ಇದೆ, ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್.
7 ಡಿಸೆಂಬರ್ ಹೇಳಿದ್ದು.
Serial number 37 ಏನಾಗಿ ಸರ್? Court of sir? Serial number 37.
Court officer. Court officer. Court officer.
Modify ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಯಾರಿದಾರಲ್ಲಿ ವಿಸಿಲ್ ಯಾರಿದ್ದೀರಾ ಸರ್?
Court officer.
ವಿಸಿಲ್ ಇರೋರ್ಗೆಲ್ಲ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಡೇಟ್ ಹೋಗುತ್ತೆ ಎಲ್ಲಾ ಕೇಸುನು, ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ. ಹೈಕೋರ್ಟ್ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್. ಕ್ಲೋಸ್ ಮಾಡಿ ಮೇಡಮ್.
ಅಲ್ಲ ಸರ್, ಶಾರ್ಟ್ ಡೇಟ್ ಬೇಕಿತ್ತು, 76 ಅದು ಅವೇಟ್ ನೋಟಿಸ್